And welcome back. Hope you enjoyed your lunch break. Tony Plohetski here with Ashley Goudeau. We have a special guest, Brad Vinson, who is an Austin attorney who has been closely following everything that has happened over the course of the past 4 days. And he's going to help us break down what we've seen thus far and what we will be watching this afternoon. So, Brad, thank you for being here.
Thank you for having me, Tony and Ashley. Appreciate it.
So, Brad, first I would love to hear your overall thoughts on the testimony that the whistleblowers have given us thus far.
Sure. I think I think Mateer was pretty good. I think that Benger was great. I think that Vassar's struggling a little bit. I think that Vassar should be a little more strong in his convictions. I think he's kind of wavering on some of the questions from the defense counsel.
Do you think he hurt the prosecution any with, that sort of going through the articles and him giving his opinion about whether or not, the attorney general was guilty of them?
Right, and I think if you're playing a numbers game on the articles.
Go ahead, Brad. We're seeing Dick DeGuerin on the screen, so I think we just want to hear who he is calling.
Sure.
Major Maxwell.
It is Maxwell. And we have talked about, this is another...
There's some documents up here.
Sorry, we're hearing a little... So having them clear as they're bringing Maxwell in. Tony, tell us a little bit about who this witness is.
Well, David Maxwell is a well-known, well-established law enforcement officer who worked for the Texas Department of Public Safety. He is one of the whistleblowers. So, Brad, I want to ask you, this will now be the fourth whistleblower that we're hearing from. Does that strike you as significant in any way?
Right. I mean, this is the picture that the House committee is trying to paint, right? That there were so many people that were so close who admired the agency, who admired Ken Paxton, and are still going against him. And these people have a lot of credibility from that standpoint. The defense is trying to clearly say that they're not, that they staged a coup, that this was an organized attempt to get money through a whistleblower claim. But obviously the House committee is establishing that these people are serious Republicans who really cared a lot about their boss and a lot about their office.
And so we see David Maxwell approaching there, about to take the stand.
Worth noting, as he's taking his oath, that this is the first time we're going to hear from Dick DeGuerin.
That's right.
In these proceedings.
Let's listen in.
As a witness in the impeachment proceeding shall be admitted. I'm sorry. I read the wrong line. Let me start from the beginning. I do solemnly swear and affirm, you've read that the evidence I give upon this hearing, the Senate of Texas impeachment, charges against Warren Kenneth Paxton Jr. Shall be the truth, the whole truth, and nothing but the truth. So help me God. Please be seated. You may begin.
If you'll move that microphone pretty close, we have a little problem with acoustics in here. Please tell the senators your name. Yep, got it.
There we go. My name is David Maxwell.
Mr. Maxwell, your last position with the Attorney General was as Director of Law Enforcement. Is that correct?
That is correct.
I want to ask you some questions about your law enforcement career. Can you tell us where you started and when?
I started in 1972 with the Texas Department of Public Safety. I went through the patrol school, graduated April 6 of 1973. Spent 8 years working highway patrol in Harris County. I promoted to narcotics in 1981 and worked narcotics in Harris County for 5 years. Then promoted to Texas Rangers in 1986.
Let me stop you there just for a second. Those of us who are raised in Texas know a lot about, or think we know a lot about the Texas Rangers. What does it take to become a Texas Ranger?
First of all, you have to have 8 years of experience with DPS to be able to apply for the position. When I applied in 1986, it was a little different than it is now, but we had to take a written examination to qualify to go before the oral interview board, and then they would score the oral interview board and combine the two, and then they took the top 5 people and put them on a list for 1 year. If you didn't get promoted in that 1 year, you went back to the first step and started over.
How long did you serve the state of Texas as a Texas Ranger?
25 years as Texas Ranger.
And when you left the Ranger service, where did you go?
I went to the Texas Attorney General's office.
What was your first position there?
My first position was Deputy Director of Law Enforcement.
And did you promote to the Director of Law Enforcement?
I did.
I want to pull up for, please, the organizational chart. It'll be in front of you. I'll ask you a couple of questions about that.
Okay.
Your name and, your name has been highlighted, and it appears to be on a level with other deputies. So what was your rank in the Attorney General's office as it relates to the Deputy Attorney Generals?
I was the Executive Deputy over Law Enforcement Division.
Is that an equal rank with the deputies that were deputies over the other divisions of the Attorney General's office?
Yes, and I was the most senior deputy.
Most senior, how?
I had more time as an executive deputy than the others who were working with me at that time.
How many employees, law enforcement officers and support staff, as well as attorneys, did you supervise?
I had about 350 employees, 205 were commissioned officers, and 19 of them were attorneys.
Were those employees spread out across the state, or were they only in Austin?
We had a majority of them in Austin, but we also had offices around the state.
What is and was, when you were director, the authority of the Law Enforcement Division of the Attorney General's office?
The authority was that of other peace officers in the state. We had jurisdiction over any type of crime that would be committed against the state of Texas.
Did you have a criteria for opening a case as an investigator to be investigated by the Attorney General's Office Criminal Division?
I did.
What was that criteria?
This is the criteria that I set up for investigating public officials. So I had certain requirements. First of all, I reviewed all the requests that came in for investigations on public officials. And we had a lot of requests, and I didn't approve but just a few every year. We already worked as many cases on public corruption as the Texas Rangers have statutory authority. So we worked.
Excuse me, Your Honor. Excuse me. Non-responsive. The question was, what was your criteria?
What was your criteria for opening an investigation?
The criteria was, at first, I had to have a sworn signed statement from the person who was making the allegation. The second thing was that I had to have a letter from the district attorney who had jurisdiction over the possible cases, saying that they would prosecute those cases if we were able to prove that a case was viable.
Why did you have a criteria such as that, particularly when it comes to investigating public officials?
I set up the criteria in order not to be pulled into situations that are strictly political in nature. I did not want us to be in the position of investigating public officials when there was really no crime being committed.
And did this criteria particularly apply to investigations of public integrity?
Yes.
Do you know who was the district attorney in Travis County in the year 2020?
Margaret Moore.
Did you have a good relationship with Margaret Moore?
I did.
I want to get right to the matters here. Were you asked in some way to meet with a person named Nate Paul?
Yes.
Who asked you to do that?
Jeff Mateer.
Where did Jeff Mateer tell you who had told him to have you meet with Nate Paul?
Objection, hearsay.
That's not hearsay under 803 and 801E2D, Your Honor, with respect.
Mr. Mateer is not alleged to have been a co-conspirator. Objection, hearsay.
It's not.
Hold on one moment. Hold on. And we've been doing a really good job of not using a lot of numbers. I have my whole chart here. It's better for just to say what the answer objection is, but this is why I have legal counsel here.
Yes, it's 801
Yes.
E2D.
Overruled.
All right, you may state your answer. And the question is, did Mr. Mateer tell you who ordered him to order you to meet with Nate Paul?
Yes.
What did he say?
He said General Paxton ordered me to meet with this individual, that he had a story to tell.
At about the same time, did you hear from an employee of the Travis County District Attorney's Office about Nate Paul?
I did.
I'm going to ask you about that in a minute, but when you first were asked to meet with Nate Paul, did you do some research of your own?
I did.
And what did you find?
I found on the internet that...
Excuse me, with all due respect to Ranger Maxwell, if he's going to recite information that he obtained doing his research, that would be hearsay.
It goes to his state of mind in conducting the investigation, Your Honor, and thus is not hearsay.
It is hearsay.
Well,
Overruled. Continue.
okay. So what did you find when you made your initial investigation of Nate Paul?
I found that Nate Paul was being investigated by the FBI, that they had run search warrants in August of 2019 on his business and his home and a storage facility. I found articles in business journals that talked about lawsuits.
Excuse me. Objection, hearsay. Articles in business journals, that's definitionally hearsay.
Again, it goes to his state of mind, and it's the same. He's answering the same question that the court allowed.
With all due respect, he can testify to what's in his mind under this exception. He can't testify as what the article said.
Sustained.
Nonetheless, did you form an opinion of your state of mind?
I did.
And what was that?
My opinion that Nate Paul was a criminal and that we should not be associated with Nate Paul.
At about the same time, did you receive a communication from the Travis County District Attorney's Office?
I did.
Your Honor, we have an agreement on House Exhibit 615, which we moved to introduce.
Could I see it, Dick, real quick? I'm sure you're right. Yes. No objection.
It's been admitted. Both sides have agreed.
If we could bring up closer, yeah. I'm being told to tell you to get closer to the mic.
Mr. Maxwell, they just asked you to get closer to the mic when you speak.
Closer to the mic?
Yeah.
Is that better?
You can pull that towards you a little bit if you'd like.
Okay.
You can pull the whole outfit closer to you.
Okay.
This is the first page. This is the email, and it references a letter. Let's go to the second page, please.
Yes, it was from Don Clemmer.
All right, here's a letter from Don Clemmer. It's dated June 10th, 2020. It's to you. And let's just read it into the record. I am forwarding to you the attached complaint, which was recently received by my office regarding allegations of misconduct by employees of the State Securities Board, the Federal Bureau of Investigations, the Department of Public Safety, the United States Attorney's Office for the Western District of Texas, and a federal magistrate. my office would typically forward such a complaint to the Public Integrity Unit of the Texas Rangers for review. However, since an employee of the Department of Public Safety is one of the subjects of the complaint, referral to the Rangers would appear inappropriate. I am therefore requesting that your agency conduct the review. My first question, is the word review significant?
Yes.
What is its significance?
In the protocols that we had set forth, we first review the request before we ever make a determination on whether we'd actually open up an investigation.
Now, you're familiar with a district attorney's office excusing or recusing itself from an investigation, aren't you?
Yes.
Is that what this was?
Yes, they were forwarding it to us. They didn't feel like that it was up to them to do this investigation.
Now, we saw the email that Mr. Clemmer sent about the same time, and it mentions that you should call him if you'd like. Did you call him?
Yes, I did.
And did you talk to him?
Yes, I did.
What did he tell you?
Excuse me, objection.
It comes in, I know he's going to object to hearsay. Under Rule 803.3, it's an expression by Mr. Clemmer of his then existing motive, intent, and plan.
Not only do I have to object, I want to object. Hearsay.
Yeah. Sustained.
Maybe I didn't clearly state my citation of the code or of the evidence rules, Your Honor, 803.3.
I've ruled. Continue.
All right. Whatever, and don't go into the words that Mr. Clemmer said, was it consistent with what you had already found or the suspicions that you already had?
Yes.
And what were your suspicions?
That the referral was being requested by General Paxton.
And what about the validity of the referral and the complaint?
Excuse me, objection, conjecture, and speculation.
Oh, this would be his evaluation, which was his job to do.
He hasn't done anything yet. Objection, conjecture, and speculation. You're asking him to testify as to the validity of a complaint which he hasn't investigated yet. That would be conjecture and speculation.
Overruled.
Let me lay a letter.
Overruled.
Okay, go ahead.
I can answer the question?
Yes.
My evaluation of the allegations made by Nate Paul is that they were absolutely ludicrous, without merit, no probable cause, not even reasonable belief that a crime had been committed.
Now let me step aside for just a moment and say, or ask you, what were the nature of the allegations that Mr. Nate Paul was making?
The nature of the allegations that he was making were against the FBI, an investigator with the Texas State Security Board, 2 U.S. attorneys, the senior federal magistrate, Mark Lane, and others who were involved in the chain of the signing and execution of the search warrants on his business, his place of storage, and also his home.
Now, one of your areas to investigate, one of your duties was to investigate public integrity, correct?
Yes.
If there had been credible allegations against the State Securities Board, the DPS, the FBI, federal magistrate, U.S. attorney, would you have any hesitation of going forward?
Objection,
No.
Excuse me, objection, bolstering, and self-serving.
Overruled. Continue.
You may answer.
No, I would not.
Did you have any hesitation even to meet with Nate Paul?
I did not want to meet with Nate Paul, and I expressed my concerns to Jeff Mateer about that.
And what was the reply?
He said that he was getting a lot of pressure from General Paxton for me to do this.
All right. Let's go to July the 21st of 2020. Did you have a meeting with Nate Paul and his lawyer?
I did.
What was the reason you had that meeting?
I told Jeff Mateer that I would consent to let him tell his story, and that if he made any statements against his interest, I would report it to the FBI.
So on July the 21st, did you have the meeting?
I did.
Where?
It was on the first floor of the Clements building. It was in the office of our security office, where we have a conference room that has the capability of recording video and sound.
Who wanted that to be done? That is, record by video and sound the meeting, but with Nate Paul and his lawyer and yourself?
Me.
Are you familiar with a report that was later put out by the Attorney General's office claiming that General Paxton wanted that meeting recorded?
That is false.
So, have you reviewed the transcript of that meeting?
I have.
Are you aware that the lawyers for General Paxton have been supplied with both the audio and video and transcript of that meeting? What took place?
Okay. Yes, I'm aware of that.
Okay. What took place at that meeting?
Say it again.
What took place at that meeting?
Nate Paul laid out his conspiracy theory about what happened the day of the search warrants were executed. He had complaints about the procedural part that the FBI took when they were securing the scene and conducting the searches. And then he laid out his conspiracy theory that they had originally come to search for not records, but for drugs and guns. And that in the middle of the search, when they didn't find any drugs and guns, they then altered the search warrant to be the search warrant that was executed, where it was for records. And he further stated that the people involved in that was the FBI agent, the agent from the Texas Securities Board, Alan Bowie, who was AUSA, and Mark Lane, the senior magistrate.
So according to his complaint, a United States federal magistrate was involved in this conspiracy?
That's correct.
As a law enforcement officer of many years, what did you think of that?
It was ludicrous.
Did you ask for any documentation?
Yes, I did.
Are you familiar with the crime of obstruction of justice?
I am.
Are you familiar with the crime of interference of a law enforcement investigation?
Of a federal investigation, yes, I am.
What concerns did you have if you had started an investigation based on these claims by Mr. Paul?
My concerns that we would be interfering with a federal investigation, we could be charged with obstruction of justice, and based on a complaint that has absolutely no merit.
And at this time, even at this meeting, had your criteria for opening an investigation been satisfied?
No.
How so?
It doesn't meet any of my requirements.
After that meeting with Mr. Paul? And his lawyer, by the way, was Michael Wynn?
Michael Wynn was there.
Okay. After that meeting with Mr. Paul, did you have a meeting with the Attorney General, General Paxton?
I did not, after that meeting, immediately, no.
No, I don't mean that same day, but did you personally talk to Ken Paxton, the Attorney General, about what had happened in that meeting?
No, I did not.
What did you tell him about the meeting?
I'm sorry. I thought he said he did not meet with Mr. Paxton. And you just asked him what he told Paxton. One of us is confused.
Can we clarify that?
Yeah, could you clarify that? Did you tell him what you thought about that meeting?
I told him before the meeting ever occurred what I thought about us being involved with Nate Paul. That happened before the first meeting.
And what did you tell him?
I told him that he was a criminal.
Sorry. Excuse me, Ranger. Objection asked and answered. He just got through telling us what he told Paxton.
I don't believe it was asked. I don't believe he answered fully what I'm driving at. What did he tell General Paxton?
I'll sustain the objection and you can try one more time again.
Maybe I'm not clear on it. Did you at some time tell General Paxton what you thought about this idea of Mr. Paul, that there was a vast conspiracy against him?
Yes.
What did you tell him?
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
Nonetheless, was there a second meeting between you and Nate Paul and Nate Paul's lawyer and Mark Penley?
There was.
Why was there a second meeting if you felt like you did after that first meeting?
Because he had talked to he had talked to Mark Penley and told him he wanted him to conduct another meeting with Nate Paul.
When you say he, are you referring to General Paxton?
General Paxton, that's correct.
So General Paxton had told Mr. Penley to get involved in this?
That is correct.
Excuse me. Objection. I'm sorry, Dick. Objection asked and answered. Ranger Maxwell will give his testimony and Dick will ask him to repeat the same thing. Ask and answer.
I'm going to overrule that. Continue.
Yeah, I wanted to clarify and make sure that we understand. Mark Penley told you that General Paxton had ordered him to now get involved?
This is the third time. Objection asked and answered. He literally just got through testifying to that.
I believe that you allowed me to ask that.
Sustain.
All right. So, did you have a second meeting?
We did.
And was Mr. Penley involved in this one?
He was.
And what was Mr. Penley's role in the Attorney General's office? If we could have that organizational chart again.
Mr. Penley was the executive deputy over criminal prosecution.
So in this chart, he's just next to you, and it's now been highlighted for them for the jurors.
That's correct.
Was he your superior, or was he an equal of yours?
He was an equal.
And what was Mr. Penley's background, briefly?
He came to us from the U.S. Attorney's Office out of Dallas, where he'd been an assistant U.S. attorney.
So at this second meeting, where did it happen?
In the same place as before, in the Clements Building, ground floor, the security office, conference room.
Was it audio, video recorded?
It was.
And is there a transcript of that?
There is.
Have you reviewed that?
I have.
Are you aware that that has been provided to Attorney General Paxton's lawyers?
Yes.
All right. Who wanted that meeting recorded?
I did.
If there's any suggestion that General Paxton wanted that recorded, is that true or false?
Objection asked and answered.
That was the first one. That was the first one that we referred to.
Overruled.
Go ahead.
It's false.
Was there anything new brought up in that meeting as far as you were concerned? You were in both meetings.
He and his lawyer again reiterated the complaints and their conspiracy theory as they had done in the first meeting. I advised them.
Objection. Excuse me.
What did you advise?
Excuse me, Dick. The objection is non-responsive. The question was there anything new? Now Ranger Maxwell is going into what he told them. That's a different answer.
Sustained.
It's correct, and I was trying to meet his objection by going to the next question. So go ahead. The next question is, what happened?
What happened? So during the meeting, they continued to lay out their objections about what happened in the search warrants and the conspiracy theory about how all these different individuals came together and falsified a search warrant during the middle of the search. And I told them that if they believe that to be true, then why aren't they in the office of the Inspector General's office for the federal government, which has the authority to look into any of these complaints, and the FBI, the U.S. Attorney's Office, the federal magistrate has to cooperate with them. And I asked them, why aren't you in that office?
Did you get a satisfactory answer to that?
They danced around the answer, but they said they felt like they were in the right place with us.
Did you receive any kind of documents to corroborate or to support that the search warrant had been changed mid-search?
They gave us some documents. They were supposed to give us all the documents, but when we reviewed the documents they gave us, it was not very much. And it certainly wasn't enough for us to really make a determination.
Even still, did you submit those documents to some experts within your office?
I did.
And what's the expertise of the people that you submitted these documents to?
This is my forensics section, who does all the forensics on computers and cell phones for criminal cases. And we do that work not only for ourselves, but for the Texas Rangers and others.
All right. By this time, which is, that meeting was August the 5th, by this time, had you become aware yet that General Paxton had ordered Josh Godbee and Mr. McCarty to push a charity to settle in a lawsuit?
No.
Objection.
And by that time...
Excuse me, Dick. Objection, leading and assuming facts not in evidence through this witness.
I'm just asking if he was aware.
Sustained.
Were you aware that Ken Paxton had asked Ryan Bangert to change the state policy?
No.
Were you aware that General Paxton had asked Ryan Vassar to release details of that very ongoing investigation?
Objection. That's a misstatement of the record, and it's assuming facts not in evidence through this witness.
Overruled.
You may answer.
No.
Did you later become aware of those things?
I did.
We'll get to that. Let's talk just for a moment about the records of a search. What is the general practice at least in federal courts, for the sealing, that is, making private the affidavit, the application for a search warrant?
They are sealed to protect people who are involved, may have given information about the crime that's being committed, and also for the purposes of protecting the investigation so it can be ongoing and find the truth.
Are you familiar with orders of federal courts to seal documents such as these?
Yes.
In this second meeting, what was Nate Paul and his lawyer's demeanor toward you and Mr. Penley?
I think that they were maybe not as gracious as they were during the first meeting. I think they understood by this point that...
Excuse me, Ranger. Object to what he thinks they understood. That's conjecture and speculation.
Sustained.
Well, what my answer is, my question is not what you thought they thought, but what was their demeanor. So what was their demeanor?
It was a little more animated than the first meeting.
Did anything happen at that meeting to change your initial assessment of whether this should be elevated to the level of an actual investigation?
No.
To clear that up, when you got this, did you start an investigation, as that term is understood?
Ask your question again.
Yes. Did you start an investigation? Did you initiate an official investigation?
No.
What do you do when you start an investigation?
When you start an investigation, you assign it to an investigator group that is assigned an investigative number and is put into the record.
And the reason that even after this second meeting, it had not risen to the level of investigation, what's that reason?
The reason was that the allegations had no merit, and we weren't going to do the investigation if I had anything to say about it.
All right. Even though, and did you make that clear to not only now Mr. Paul and his lawyer, but also Mr. Penley?
Yes.
Even though that was your position, did you agree to submit their documents to your experts within the office?
Yes.
Okay. So was there a third meeting?
There was.
When was that third meeting?
It was on August 12th.
Was it clear to you by then what General Paxton wanted done?
Objection, conjecture, and speculation.
Was it, well, let me clear that up. Was it clear to you from what General Paxton told Mr. Mateer or Mr. Penley what General Paxton wanted done?
That's actually worse. That's hearsay and conjecture and speculation.
Actually, no, Your Honor, it's under 801E2D.
Counselor, you're going to make me look at these numbers, aren't you?
Yes, Your Honor.
He's just trying to throw you off.
801E2E says that a statement such as this is not hearsay, particularly
with respect.
when it is, excuse me.
I'm sorry, you did go ahead.
Particularly when it was made by the party's agent or employee on a matter within the scope of that relationship. And here it's what General Paxton told to either Mateer or to Penley that was passed to the witness.
With respect,
that is not hearsay.
I'm sorry, Dick. With respect, Your Honor, there's a difference between what General Paxton said and what Ranger Maxwell can opine about General Paxton's state of mind. Those are two different things.
Not asking that.
You just did.
Sustained.
Well, let me ask it again then, if that's how it was understood. What message was passed to you by either Penley or Mateer that General Paxton had ordered done?
General Paxton wanted to have a third meeting.
I'm sorry. Objection. Objection, conjecture, and speculation. I have no problem with Ranger Maxwell testifying as to what General Paxton said, but there's a difference between what he said and what he wanted. I know it's splitting a hair, but objection, non-responsive.
Sustained.
What did he say he wanted?
He wanted us to tell Nate Paul that we were not going to be doing an investigation due to the results of our forensic analysis.
So going into that third meeting, is that what you believed it was going to be about?
Yes.
Was that meeting recorded like the first two?
No.
Who was responsible for it not being recorded?
General Paxton specifically told us that he did not want that meeting recorded.
Okay, so as you're going into a meeting in which you believe it's just for you to tell Nate Paul that you're not going to do his bidding, what happened?
The Nate Paul was there along with his lawyer, Michael Wynn. I had my two forensic experts, Mark Penley, myself, and General Paxton. My forensics people explained to Nate Paul the results of their forensic examination.
And very briefly, what was that result?
That the metadata that he was talking about that had changed could have been changed by the fact that there were documents he received had been electronically redacted and encrypted, which would change the metadata.
Is that a long way of saying there was nothing there?
Yes.
So, your understanding that General Paxton was telling you tell him not that you're not going to have an investigation. What was General Paxton's? What did he say during that meeting?
During the meeting, he was supporting Nate Paul's position, which was that we need to do an investigation. And he was pretty adamant about it.
Was that meeting heated?
It became heated.
Who became heated?
Nate Paul.
Before that meeting started, were you aware of any public statements that Mr. Paul had made about whether there was an investigation?
Yes, I was.
And what were those public statements you were aware of?
He had done an interview with a business journal and told them that the Texas Attorney General was investigating the FBI and their handling of the search warrants again on his property.
Was that true or not?
That is false.
In fact, you had not started an investigation, correct?
We had not, and I specifically told Mr. Paul that we were not doing an investigation at this point, and our meetings were confidential.
And the response?
Oh yeah, he responded.
What was his response?
He was very angry, and he said that he still has a First Amendment right. And I told him that all you're doing is using the power and the prestige of this office for your own purpose, and I'm not going to allow that.
Whose side in that dispute between you and Nate Paul did General Paxton take?
Nate Paul.
So, what was the significance of Nate Paul making a public statement that the Attorney General's office was investigating a federal magistrate and the federal authorities and the state authorities that the Attorney General was investigating? What's the significance of that kind of public statement?
Excuse me. Objection, conjecture, and speculation.
Sustained.
All right. Why did you think, what was your state of mind about why such a public statement when it was not true about the Attorney General investigating these law enforcement people? What was your state of mind about why that was improper?
It was improper because Nate Paul was a criminal, and General Paxton was using the office to his benefit.
Can the very start of an investigation into a public figure be damaging to that public figure?
Yes, it can.
I'm sorry.
Is that?
Excuse me, Dick. Pardon me, Ranger. Objection, conjecture, and speculation.
Overruled.
You may answer.
Repeat the question.
Yes. Can the very public start of an investigation against a public figure be damaging, almost like a tattoo to that public figure?
I got to object to leading in the tattoo. I'm sorry. Objection, leading.
Well, I'll reverse it. I'll take
Sustained.
the tattoo out of
Take the
it.
tattoo
Sustained.
out.
If I take the tattoo out of it, may I ask the question again?
I just sustained that. You can try whatever you'd like to and see what he objects
Okay.
to or not.
Is there a danger to a public official's reputation by publicizing an investigation by the Attorney General, and especially when it's not true?
Yes, very much so.
Is that the reason you're very careful about having a criteria for starting an investigation?
Objection, leading.
Sustained.
What is the reason you're careful
We're
about
careful. We're careful because we don't want to put a stain on anyone's reputation. It has to be an investigation that is viable, has probable cause, and could move forward. This was not that.
All right. So let's talk about what happened after that meeting. Did you ever have any further conversations with Attorney General Paxton?
No, Attorney General Paxton stopped talking to me.
And your assessment at that time of whether General Paxton was angry with you?
Excuse me. Conjecture and speculation.
It's his state of mind.
Sustained. You can ask it differently if you'd like.
All right. Your state of mind after General Paxton and you left that meeting was what? About General Paxton?
Unless he said anything, conjecture and speculation. He's got nothing to base it on.
Overruled.
You may answer.
I know his state of mind because in the meeting he threatened to fire me. So I knew then what his commitment was to Nate Paul, and he was not going to be deterred from continuing to try and do things that benefit Nate Paul.
During this period of time with these 3 meetings, had you called upon any of your subordinates, any of your other investigators to, other than to look at this metadata, had you called on anyone to assist you in this review?
No.
Why not?
I told my people that this was going to get me fired. I was going to take the stand, and I was not going to jeopardize any of their careers by involving them.
Why did you think it was going to get you fired?
Excuse me.
He demonstrated his commitment to
Ranger.
Nate Paul.
Witness, hold one moment. Your
State of mind.
objection?
Objection, conjecture, and speculation.
Overruled.
For his state of mind. Yes, you may answer.
he had already told me that if I conducted my business as the FBI does, that he was going to fire me. So I know that he was angry with me because I was not buying in to the big conspiracy theory that Nate Paul was having him believe.
And at this time, did you know that there was some action within the Attorney General's office to hire an outside counsel to do what you refused to do, and that is conduct an investigation into the federal authorities that were hounding Nate Paul?
I'm sorry.
Take out hounding, that were conducting their investigation on Nate Paul.
Objection vague. When is this time? I'm not sure where we are.
I'll clarify.
Sustain, clarify, please.
At this time, we're now talking about the end after the third meeting. Did you know that there was some movement for General Paxton to demand the hiring of a special counsel or an outside counsel? Did you know about it at that time?
No.
As far as you were concerned, was the Attorney General's office involvement in Nate Paul's complaints about how he'd been treated or mistreated, in his words, by the investigation into his activities? Was the Attorney General's office involvement over?
No, I didn't think it was, because I knew that he was probably going to fire me and hire somebody who would do it.
Excuse me. Objection, non-responsive. And conjecture and speculation. With all due respect to Ranger Maxwell, he's not the amazing Kreskin. He can't see everything in the future.
I'm asking for his state of mind.
Overruled.
You may answer.
Yes, I did not believe that General Paxton was going to stop pursuing this investigation.
Did you at that time, though, know about the hiring or attempted hiring of Brandon Kamak, the young lawyer from Houston?
No.
Did you find out about it later?
I did.
I want to jump ahead now to the very end of September and the beginning of October. Did you go on a vacation toward the end of September?
Beginning of September.
Yes.
And where'd you go?
We went to Colorado.
Did you learn, don't tell us what was said yet, but did you learn that there was a crisis of sorts among the deputies, your fellow deputies, in the Attorney General's office?
I did.
How did you learn it?
They contacted me.
And did you, even being in Colorado, they have phones up there last time I checked, were you able to communicate with your fellow deputies?
I had to drive down the mountain to do it, but yes, I did communicate with them by phone.
What did you learn?
I learned that all the executive deputies, including Jeff Mateer, were going to stand shoulder to shoulder with me and confront General Paxton with what he has been doing to the agency for the benefit of Nate Paul.
What about a plan to go to the Federal Bureau of Investigation to report what they believed were, and what you believed, I believe, were crimes being committed?
Objection, leading.
What did you learn?
And again, what time frame are we talking about? Your question was late September.
Time frame is the end of September.
Sustain, re-ask.
Time frame is the end of September. In your conversations with your fellow deputies, what did you learn the plans were?
I learned that they were going to report the activities to the FBI. I learned that they had written a letter to General Paxton. I was not present, so I could not sign it. And I told them that I would also contact Lieutenant Colonel Randy Prince with the Texas Department of Public Safety and also tell him what was going on and that we were going to request an investigation.
So by You knew Lieutenant Colonel Prince as a fellow Ranger, didn't you?
Yes, I broke him in.
And so by reporting to the Department of Public Safety, Lieutenant Colonel Prince, where was he in the hierarchy of the Department of Public Safety?
He is number 2, or he was number 2 in the department. He's now retired.
And at the time that you did that, were you making a report to law enforcement about General Paxton?
Yes.
What did you think would happen to you as a result of you reporting General Paxton to authorities?
Conjecture and speculation, Judge.
State of mind.
Judge, everything that doesn't get to come into evidence as state of mind.
Overruled.
You may answer.
I was going to be fired.
What happened on, I believe it was October 2nd, 2 days after the report? What happened on that date regarding you?
I received notification by text message from Greg Simpson, the division chief over human resources, notifying me that I was placed on investigative leave.
As a result of being placed on investigative leave, what did that do to your responsibilities in the Attorney General's office?
At that time, I had no responsibilities, had no access.
And how long did that situation last?
For 1 month.
What happened then?
On November 2nd, 2020, I met with Brent Webster, and he terminated me.
Stop you. Who was Brent Webster by that time?
Brent Webster was the new first assistant hired by General Paxton.
Would you describe for the Senate and the senators what happened when Brent Webster fired you on, did you say November the 2nd?
Yes.
Go ahead.
I was told to show up at 9 a.m. In the conference room next to Human Resources, and that I would be meeting with Brent Webster.
Were you still a law enforcement officer?
Yes.
Were you told anything about whether to bring a weapon or not?
My division chief over Criminal Investigation Division called me on the telephone when I was en route to the office, and he told me that Brent Webster said that I would not allowed to be in the building if I was armed.
So what happened after you went to this, or showed up at the time you were supposed to show up?
I got there before 9. I'm pretty much always early. And I waited till about 11:30 before Brent Webster showed up.
What happened then?
Brent Webster and Aaron Wrights came together, and they first asked me if I was recording this meeting, and I said no.
And you were not?
I was not.
Did you ask them?
I asked them if they were recording the meeting, and they said they were not.
And then what happened?
Then Brent Webster told me that he was conducting an investigation.
Did you believe that?
No.
And in fact, did his actions confirm your non-belief?
Yes.
What happened then?
So he attempted to interview me in a very vague and inept way, and I told him, just ask the question, I'll answer it, or I won't answer it. Just give me a direct question, and I'll give you what you want to know. We never got to the point where he asked me any really direct questions.
All right. How did it end?
He left, and he told me to be back at 1 o'clock. And so I went to have some lunch, and I came back to the office at 1 o'clock.
Did he show up?
No.
What happened?
Yeah, about 4:30, members of Human Resources showed up with my paperwork, and I signed the paperwork, and I was fired.
I want to talk just a moment about what I'll call retaliation. Were you retaliated against for what your actions that you took in this case?
Yes.
Tell the members of the Senate briefly how you were retaliated against.
That he retaliated against me, is what you're asking. Well, in firing me, at the time I was 71 years old and had risen to a top level of law enforcement. In effect, when he fired me and then berated me in the news, he ended my career.
By that time, your career had taken up how many years?
It was 48 years.
Were you proud of your career?
Absolutely.
What is an F5 form? That's an F as in Frank 5, the number.
It's a TCOL form.
TCOL means what?
Texas Commission on Law Enforcement.
What's the importance of TCOL?
TCOL is the regulatory agency for all peace officers in the state of Texas.
And so what happened at first with regard to your TCOL license and the F5 form?
The F5 form is a form that is required for the agency to fill out anytime they separate from a law enforcement officer. There are 3 things that you can mark on the F5. It can be an honorable discharge, it can be dishonorable, or it can be a general discharge.
Is a general discharge good or bad?
Bad.
Did you contest that?
I did.
Did you join in the filing of a whistleblower lawsuit? We call it that. Why did you sue?
I sued because he ended my career in a very unjust manner.
Eventually, partly as a result of the lawsuit, was the general discharge reversed and you got an honorable discharge.
Yes.
Is that important?
Yes.
Why?
Because it's important to me to show that I had an honorable discharge and that I did nothing wrong by standing up for right.
Pass the witness.
Mr. Goudeau?
Thank you.
Take as much time as you need.
Thank you. You good, Dick?
Yeah.
Good afternoon, Ranger.
Good afternoon, Counselor.
How are you?
I'm good.
Good.
Mr. Goudeau, I'm sorry, since you're a little taller, you're going to need to get closer to that microphone so we can
Wait, I'm taller
raise
than
that
Dick?
up. There you
Good.
go.
All right. It's been a minute, has it not?
I confess.
Sir?
I confess he is taller. And in fact, well.
It's been a minute since you and I have seen each other.
It has.
Let me go into sort of your preparation for this hearing. And Ranger, I know you as Ranger Dave Maxwell, so I'm going to call you that whether you want it or not because it's just in my brain.
I'm good with that.
That good. What have you done in preparation for testifying here today, Ranger Maxwell?
I've consulted with the attorneys. I've reviewed the material that has been turned over that I would be speaking about.
And is your lawyer here?
Yes.
Tell me his name.
T.J. Turner.
And he's in the room.
He is.
Now, when you say that you have consulted the material, let me make sure I'm on the same page with you.
Okay.
I'm aware, Ranger Maxwell, that there are transcripts of your original meeting with the Board of Managers back in February. You've read that transcript, I assume?
Yes.
There is the July 21st, 2020 interview by you of Mr. Wynn and Mr. Paul, right?
Yes.
I assume you've read that transcript?
I have.
There is the August 5th, 2020 interview by you and Mark Penley of Mr. Wynn and Mr. Paul, correct?
Yes.
There are also videotapes. I think the first one is about an hour, the July one, and the second one is an hour and a half or so.
Hour and 17 minutes, an hour and 54 minutes.
Your memory is not lacking. I'll give you that, at least so far. But have you seen the videos as well, Ranger?
No.
Okay. Well, I may ask you some specific questions about those meetings. So let me give you copies of the transcript, Ranger, just so if I get down in the weeds and you need them, you'll have them. Okay?
So, it's good.
May I approach, Your Honor?
Yes, you may.
Ranger, the Board of Managers,
Okay.
the July and the August.
Okay. Good.
He was not on mic, but he was simply pointing out to the witness what the different folders were.
Let's go back to, I guess, your first involvement, Ranger, with this particular investigation in terms of your testifying, okay?
Okay.
And by what I mean by that is when you were interviewed back in February, I think, by Therese Buse and Dan McAnulty.
Yes,
You remember that interview?
I do.
You've read it.
I have.
And in reviewing that transcript, Ranger, in your review, did you see anything that was an error or a mistake?
I see some things that may be misconstrued
What are those things?
about Drew Wicker and what he may or may not be able to testify.
Gotcha. Now, let me put you on pause there. You weren't here, obviously, during the opening statements, so you don't
No.
know what was said or what wasn't said about Drew Wicker and your statements about Drew Wicker. You weren't here, right?
No, that's correct.
Have you met with Mr. DeGuerin or anybody from the Board of Managers team in anticipation of your testifying?
Yes.
Who did you meet with?
I met with Mr. DeGuerin, Rusty Harden, met with the other attorneys that are helping prosecute this case.
Okay. And was that topic brought up in the meeting? That is what you said in the February meeting about Drew Wicker?
Yes, they did ask me about that.
Okay. Now, you know Mr. DeGuerin personally,
Yes.
and to jump way back in time, which was one of the first times I met you, Mr. DeGuerin famously walked into the Branch Davidian compound during the siege in 1993.
93.
Were you escorting him in and out? Was that you?
No, I did not.
But the Rangers did have a significant role in the investigation of that incident, that tragedy, whatever we want to call it, right?
Yes, I was one of the lead investigators.
Yes, sir. And if my memory serves me, Ranger, correct me if I'm wrong, but I think you helped a much younger me get access to my client in that ordeal. Did you not?
I did.
Thank you, sir. Now, I mean this sincerely and respectfully, Ranger. You're an icon with the Texas Rangers, right?
I don't see myself that way.
Well, a lot of folks do. You'd agree with me?
I've heard a lot of people say that, yes.
You are in the Texas Ranger Hall of Fame, right?
Well, at some point.
What do you mean at some point? You are now.
I am not an official member of the ones they recognize as being in the Hall of Fame. My picture has been there. There was once an exhibit on me in the Hall of Fame.
Well, let's see, you joined the DPS in 1972.
That's correct.
You became a ranger in 1986.
Yes.
You left the DPS, and I'm sure 95% of the people in the room know this, but some folks watching on TV may not. All of the Texas Rangers, the genesis of being a ranger, you hail from the Department of Public Safety. That's the outfit through which you become a Texas Ranger, right?
Yes, because the Rangers are a part of the Texas Department of Public Safety.
Yes, sir. So all told, with the DPS and the Rangers, your career lasted 38 years?
38 years.
Now, you made some statements to Mr. DeGuerin about how ludicrous it was to be investigating judges or assistant United States attorneys in this particular case, right?
Yes, in this particular case.
Yes, sir.
That's correct.
But certainly you would agree with me, Ranger, that in your experience, you have been part of investigations, even prosecutions of assistant United States attorneys or judges, right?
I have investigated and prosecuted public officials. I've never investigated a senior federal magistrate or an AUSA.
Well, let's go back to the Waco incident. One of the fallouts, tragically, for one of the assistant United States attorneys in that case, a fellow who I actually respect a lot, so I'm not going to mention his name, but I think you know who I'm talking about.
I do.
He was charged with a federal offense after that ordeal, was he not?
He was.
Now, you mentioned OIG, which is the Office of Inspector General, right?
Yes.
And they are kind of like, I don't know what you'd call them, OPR or what is it in local law enforcement when you have a complaint against a law enforcement officer? Help me with the verbiage.
I don't think we on the state level have an equal to the Office of Inspector General because they cover all of the federal agencies as far as being able to inspect them. We don't have that in Texas. We don't have oversight of other agencies.
Okay, fair enough. But would you agree with me that in your experience as a Texas Ranger, you've seen, wrongful prosecutions of DPS agents?
Yes.
One of those was a fellow by the name of Sergeant Bob Nestoroff. Remember that?
I do remember Bob, yes.
He was I think, head of DPS narcotics enforcement.
He and I were in narcotics at the same time.
And he was charged by an AUSA in Florida, if I remember, for perjury and obstruction.
He was.
Came here and went to trial in Houston in front of Lee Rosenthal, right?
Yes.
You remember his lawyer, right?
I don't remember who his lawyer was, no.
Objection for a moment, Your Honor. Relevance.
Well, my point is this. No one...
Relevance.
Overrule. Let him continue.
Well, let's just say his lawyer looked like a 27-year younger version of me, but that's not really the point. The point is even AUSAs can make mistakes, right?
You're talking about one individual.
Yes, sir.
Yeah.
One individual that charged a compatriot of yours for something he didn't do.
Yes.
Okay. My point is it is not beyond the realm of possibility for anyone, including an assistant United States attorney, to make an error in judgment or whatever that ends up being criminal. Agree with me? It's rare, but it happens.
It's rare, but it happens.
Now, let's talk about the resources through your 38-year career, Ranger, that you've been exposed to. You would agree with me as a general rule that you have seen the tools and the resources available to law enforcement grow exponentially in your time.
Absolutely.
There are kinds of investigative tools that weren't around when you started with the DPS or when I started practicing law that are around today? You agree with me?
There's no comparison.
Yes, sir. Things like Crime Star,
Yes.
things like Clear for law enforcement, it's public records database, right?
Yes.
Accurate for law enforcement, again, another public records database, right?
Yes.
TLO by TransUnion, another law enforcement public records database, right?
Yes.
Cellbrite, a cell phone analytics tool, right?
Say that again.
Cellebrite, it's a cell phone analytics
Yes.
tool.
Mm-hmm.
Gray Key, another cell phone analytics tool.
Yes.
PenLink, another phone analysis tool.
Yes.
Obviously, TCIC, NCIC searches, right?
Yes.
Criminal history checks, driver's license checks, right?
Yes.
Access to some utility companies' databases, right?
Yes.
Open source data like YouTube, Facebook, Twitter, X, all those sorts of things.
Yes.
And 95% of that just wasn't around when you started your career, right?
Absolutely.
So you would agree with me, I think, Ranger, that if you don't know how to use those tools, you could certainly find somebody that could help you use some of those tools if you wanted to use them. Agree with me?
Agreed.
Now, the DPS and the Rangers have all kinds of teams at their disposal, right?
Yes.
They have a reconnaissance team, agreed.
Yes.
A special response team, agreed.
Yes.
A public corruption unit team, agreed.
Yes.
It is not unusual at all for DPS or the Rangers to participate in internal investigations, right?
That's correct.
DPS from time to time, I am told, triple hearsay, uses hypnosis.
We used to. I think that's been phased out now.
Did you yourself?
No, I didn't want.
You never did?
I didn't want to do that.
Your legend has been diminished by just a bit. I thought you used hypnosis. All right.
No, sir.
Now, you yourself, Ranger, you have taught all kinds of courses, right?
Yes.
You personally taught on how to conduct investigations.
Yes.
Agree? You have taught on interrogation techniques.
Yes.
Agree? You have taught on how to testify in court.
How to what?
Really? You just did that? Come on. You have taught on how to testify in court.
Yes.
And no disrespect to anyone, this is not your first rodeo. You have testified a few times, right?
That's correct.
Can you estimate for us, Ranger, how many times you have testified in courts across this state or across this country?
Hundreds.
Okay. Now, simply put, Ranger David Maxwell knows how to conduct an investigation if he wants to, right?
Yes, that's correct.
And you have literally conducted probably thousands of investigations?
Yes, thousands of investigations.
I guess, Ranger, anything from traffic tickets to capital murders and everything in between you've investigated, right?
Yes.
Now, let's talk for a minute about the good traits of an investigator. See if we can agree on a few good basics. One, they should have the training and the mental tenacity to be a good investigator, right?
Say that again.
They got to be smart enough to know what they're doing.
Yes.
They should have an open and objective mind.
Yes.
They should go into an investigation without bias or predisposition.
Yes.
They should be willing to follow the evidence.
That's correct.
And they shouldn't make assumptions that aren't based on sufficient evidence, right?
Yes.
Now, it is also important, is it not, to follow up on any leads or information given to them by others?
I lost some of that. Say it again.
And I couldn't help but notice you've got a hearing aid.
I do, and so it's a little hard for me.
Yes, sir. And if I don't speak up enough, please
All right.
let me know.
Thank you.
It's important for a good investigator to follow up on any leads or information that's been given to them, right?
Yes.
Would you agree with me, Ranger, that a good investigator understands that, you know, we're kind of all equal under the eyes of the law in terms of everybody's entitled to have an investigation, at least if it's warranted by the facts, investigated, right?
Yes.
An inmate or a president or anything in between. Agree with me? An investigation should be thorough.
Yes.
And accurate records and reports should be generated and maintained.
Yes.
And that's important not only for the investigator that's involved in the case, but really for the future of the case, right?
Yes.
I mean, investigators leave, they get fired, they quit, but the case may still be going on, right?
That's correct.
So once again, you have the experience, the training, the assets, the knowledge, and the relationships and the contacts to do a great investigation if you were inclined to do that, right?
Yes, I do.
All right, let me ask you, and I think Mr. DeGuerin touched on it briefly, but let me do it as well. I think he mentioned a search warrant and a probable cause affidavit, right?
Yes, he did.
Where is the, I have just a minute, Your Honor. Affidavit itself. Right. Well, while he's looking for what he should have had, Eric, while he's looking for that, let me cover a couple of things with you, Ranger. First off, the quantum of proof that a search warrant must satisfy before a judge or a magistrate signs off on it is probable cause, right?
Yes.
And the lower standard of proof is scintilla, and then we go into probable cause, then we go into clear and convincing, and then we go proof beyond a reasonable doubt. You're aware of all those things,
Yes.
right? Now, thank you. I'm going to show you, Ranger, I don't know that if you have seen this or not, but I'm going to show you, without offering it for obvious reasons, the underlying affidavit in support of the search warrant for Mr. Paul's properties and the search warrant itself, okay?
Okay.
May I approach, Your Honor?
Yes, you may.
Good for right now. Sure. I'll need some later, though.
Yes, let me know.
All right.
So what you have in one hand is a search warrant, which is pretty thick, right, Ranger?
Yes.
You should have, and if you'll pull forward, Ranger, because we got to have your voice pull forward.
sorry.
That's all right.
All right.
You should have two different things. One is a part of the other, but one is the greater search warrant, which is several inches thick, right? The entire search warrant.
Yes.
And then included in that, which we've excerpted out, is the search warrant affidavit or the affidavit in support of the search warrant, right?
Okay.
Now, you have prepared estimate for us, Ranger, how many search warrant affidavits?
I couldn't tell you. I mean, it's a lot.
A lot, like thousands.
Yeah, it's a lot.
Now, you would agree with me that the content that goes into a search warrant affidavit is meant to do really one thing and one thing only. And that content that is to go into a search warrant affidavit is to convince a magistrate judge that there is probable cause for the issuance of a search warrant to search a given premises or a given location at a given time, right?
Yes.
And what's important is not the personalities of the judge or anything to do with the prosecutor or anything to do with anything other than what information would establish probable cause, right?
That's correct.
Now,
Excuse me, objection. And I object to any further reference to this affidavit as it was not part of his review and he's not seen it before.
I'm happy for the ranger to take a few minutes to look at it, but these are, Dick, I think they're going to be pretty global questions. But if the ranger needs time to look at it, I'm happy to stand down for a few minutes.
And we also object to relevance.
The relevance is what Mr. Hardin has suggested time and time again about how the search warrant affidavit could endanger the lives of judges and prosecutors and all this. I'm going there. I'll show you the relevance.
I'll overrule the objection, but Ranger, do you need some time? Would you like 5 or 10 minutes to look at it? It's a good time to break. Members, be back at 2:45.
Thanks, sir. Good to see you.
And we've been listening to testimony from David Maxwell. He is a law enforcement officer with nearly a half century of experience.
So I'm on chemo stuff every day. Sometimes I have hot flashes, so if I start sweating because I'm having hot flashes. Okay.
I realize that after I said it one time. I know.
Oh, I'm sorry about that. Good to see you. Thanks. Yeah. If you want to take a break.
The chamber is starting to take their break for the next several minutes, actually. And I want to bring in, we have a guest this afternoon with us, Brad Vinson, who is a local Austin attorney. And Brad, I want to, ultimately talk about your overall thoughts about how things are going. But my goodness, I want to talk about the testimony that that we just heard from David Maxwell. What were your thoughts?
I mean, I think David Maxwell's testimony was pretty devastating for the defense. I think that witness was about as true of a Texan as there are out there. He spent a lifetime working for DPS and for Texas, for the government. And to think that this individual would go against the AG's office and the AG himself and do it without any merit is it's baseless. It seems impossible to believe.
So let's walk through the content of his testimony. I mean, he talks about being asked to essentially have this meeting with Nate Paul, during which Nate Paul unravels this conspiracy theory about different segments of law enforcement, State Security Board, the FBI, magistrate judge. First of all, let's just talk about that. How inconceivable is that? Right,
it's very inconceivable, and I think Maxwell pointed it out. The thing that really kind of above all of that really bothered him was the fact that Nate Paul believed that a federal U.S. magistrate was involved in a conspiracy. And what Cogdell's trying to get at some in his cross is that, hey, in your long career, you've investigated public officials. And he very specifically said never a federal official of that gravity. But he had no qualms about saying that Nate Paul is a criminal. He said it several times on the witness stand, and he said that this conspiracy was baseless. And he also said that he believed that based on his discussions with Attorney General Ken Paxton, that they were not going to go forward with the investigation. And he was kind of surprised. They walked into a meeting. He was told beforehand that the investigation wasn't going to go forward. They walk into a meeting and Ken Paxton flips.
One of the things that we have talked about and pointed out, and that is testimony from these whistleblowers who say, look, as one of Ken Paxton's aides, our job, we felt, was to protect him and to support him. And then you have David Maxwell saying, I told the Attorney General that if he kept associating himself with Nate Paul, he was going to get indicted.
What a powerful thing for one of your employees to come to you and say, if you continue working with this individual, I believe you are going to wind up getting yourself indicted. That's so powerful.
And then let's talk about sort of the inside of the meeting. David Maxwell talks about 3 meetings. Mm-hmm. We know that the 3rd meeting that Ken Paxton was there. Right. He talks about the emotion of Ken Paxton being angry What was your reaction to all of that?
Well, it's interesting that yesterday the defense tried to establish, I think it was through Vassar or Banger, that the Attorney General Kim Paxton was a nice, kind man. You know, he was all of these, you know, soft things, and here we are hearing from this old Ranger that he was very much not that way when it came to Nate Paul. He was very defensive. He was angry. He was hostile. So hostile to the point that Mr. Maxwell ends up getting fired because of his opinions on this issue.
And what do you think of that? I mean, the fact that he was fired, you know, there was an issue with his F5, which is a form that law enforcement uses to kind of keep track and keep appraisal of law enforcement. You know, he said he had to fight to have you know, a certain box checked on that form.
Right. I think he was released under a general discharge, and he went back and fought the fact that he wanted an honorable discharge for his personal life and career that he devoted to the state. And I think if we're talking about votes, we're talking about how are the votes going to land in this particular case. How are the Republicans that we're questioning are going to vote guilty or not guilty going to still come out and have these strong advocacies for law enforcement and not back that man?
Let me ask you this. We were starting to see Dan Goudeau go down this road of, you know, talking about law enforcement making mistakes, that yes, law enforcement and others can fall themselves under investigation, pointing to David Maxwell's experience in Waco, for example. Where's he going with all of this?
You know, typically whenever you're cross-examining someone that's in law enforcement, you want to build them up, right? You want to build up whatever their training was, whatever their experience is. You want to tie them to their law enforcement reports so that when you start going down the path of discrediting all that, you've said, well, you've been taught differently. You were taught differently at the academy. Your experience told you differently, but you did something outside of what you would normally do. And I think that's what Goudeau's getting at. But I don't know why he would have spent so much time bolstering. He's spent so much time doing it that I almost felt like it started to help the House committee side. So
let's take a step back. I know that you and I have talked a couple of times during the past 4 days, but I'm just curious now that we're in sort of this moment of pause about your overall impressions about how this is going.
Right. I mean, there's very clear arguments on either side. I'm a lawyer, and that's what we do. We see either side. I think that the evidence is pretty overwhelming, but I think there is obviously an avenue through which the defense is trying to go. And I think that's all based on the articles. You know, if you play the numbers game on the articles, there was 20 originally. We abandoned 4 before we proceeded, so leaving 16. Mm-hmm. And when you break all those down, there are 4 that are kind of catch-all provisions, right? Those catch-all provisions are less tied to elements and more tied to just general, how do you feel? Like, does it pass the sniff test or not?
Right.
And if I was the defense, I would argue that those last 4 are dispositive of the other ones, right? So if you're going to say, hey, if you find him not guilty on these other ones, then 16 through 20 are just easy not guilties, right? So then you go in and you start breaking down those other articles. 4 of those are whistleblower claims, right? And they've spent a heavy amount of time cross-examining the motivations behind these whistleblowers. And unfortunately, I will say one of the things that Vassar said, it didn't come off well on the stand, was he was asked, why did you file this lawsuit? And he said, for money. And he followed it up later and said it was for his family and all of that, but that's exactly what the defense is going to try to say. That they'd staged this, they did this on purpose, that they came out publicly, so that they would then be fired, and then they would have the ability to go forward with a whistleblower claim. So that would be the attacks on the whistleblower articles. But then you've got these other articles that exist about the midnight opinion, and then you've got the quid pro quos regarding the affair, and then the home improvements. And so I think we're just going to have to see how they handle those. How do they present evidence on those? Is it going to be enough to give these Republicans who were questioning the ability to come forward with a straight face and vote not guilty? Mm-hmm. And I don't know. I guess we're going to have to see where the rest
David
of
Maxwell is not helping them. It would not seem he is not helping them. He is not helping them do that.
Not at all. If Ken Paxton is found not guilty, then like I said, it's a bit of a snub towards law enforcement, I think. It's a bit of a snub towards a lifetime that this man devoted to Texas.
I want to go back and just kind of talk a little bit about this idea of you know, you believe you are a victim of some sort of law enforcement corruption. Right. What is, I mean, I guess one proper venue we're seeing for that according to Maxwell at least, is the Inspector General's office for the federal government. But, Brad, if I brought the same claim to you that my home was raided and I have, formed an opinion or formed a belief, formed a conspiracy theory, as David Maxwell calls it, that, look, the cops have altered this warrant. The federal investigators have altered this warrant to say they were searching for something that other than the original target. What is the proper thing to do? I mean, what is the proper venue for that?
We certainly don't want people having their federal civil rights trampled by, federal law enforcement, and we don't want that happening on the state level either. And so if someone came to you with a claim like that, then of course the first thing you would do is begin investigating it, right? You would ask that individual for everything they have in their possession, why they believe this, and then you would try to follow the proper channels. And the channels were followed not so properly in this case, right? And we see that with what would have been the proper channel was getting the DA office in Travis County involved. And there's those two lunches, I think one with Margaret Moore and one with her first assistant.
Yeah.
And they realized that they shouldn't have been involved. And so they kind of, I think, defer that, right?
Yeah. We, Travis County District Attorney's Office, are not going to investigate the FBI.
That's right.
Yeah.
And what a wild question to ask. And it certainly doesn't seem like the right channel to hire an outside counsel, inexperienced attorney to come in and then also do the same thing, investigate the FBI. I think the proper channels would be to open an investigation, begin doing your analysis, see what evidence exists to see if there's any merit on this, and then, eventually maybe file a lawsuit. But what happened here, I don't think was that.
Are you surprised that we are spending so much time on the whistleblowers themselves?
I'm not. I think they really go to the bulk of the House committee's case, right? That these people who were so tied to the office, who were so tied to the Attorney General themselves, were so overwhelmed with how bad this evidence was that they flipped, right? That they went the other direction. So I'm not surprised that they're really laying it on that all of these lifelong government workers would have come forward with such serious claims.
Well, who's next? First of all, do you go through all 8 of them? Do you drag all 8 of them up there, or?
I don't know. I think after this guy, we would probably end here because he's just knocking it out of the park. I feel like he's talking to us as if he's sitting on his couch at home and he's on live TV in front of the country. So I think after him, you probably stop at the whistleblowers, and then I don't know. I think the people would probably want to hear from the Travis County District Attorney. I think Margaret Moore would be a good witness to hear from. And then I think, obviously, we have to hear from Nate Paul. I mean, he's going to sit up there and object, and say Fifth Amendment again and again and again. But I think hearing that over and over and over is, again, another devastating thing for the defense.
And then what about the mistress, the woman with whom Kim Paxton was having an affair?
Of course, she should be called forward as a witness.
And who calls her?
I mean, either side can call her, right? Either side has subpoena power. Either side can subpoena a witness. She would be clearly an adverse witness to the House committee side, so they could call her if they wanted to.
I want to ask you this. Certainly a lot has been made over Ryan Vassar's testimony.
Sure.
I just want to kind of go through to see if you personally believe that Paxton's defense team landed any punches in that.
I think that Vassar, I will say, he seems to be a very intelligent guy. He's a lawyer. He had a high position at the AG's office, and I think he could have been a little stronger with his convictions. I think it was right there, but he felt cautious to answer things, and it came off in a way that was not as great as the second witness that testified.
Bangert.
Bangert, Bangert. Yeah. So I think that there were still some emotional points there, right? So like on direct, when he talked about being characterized as starting a coup and being a rogue employee. That he was emotional that he dedicated his life this way. And then the defense brought in his text messages that show that he was making some gallows humorous jokes about that. But
does that land?
I don't think it does. I mean, I think that people say all sorts of things for any reason. When you're going through an emotional situation, of course you're going to make some jokes about it to just try to live with it, right? To try to live with the publicity of such a serious firing and accusations like that. So, yeah.
And can you please, for people who are struggling to follow this.
Sure.
What is the significance of, well, first of all, is there a significance to the letterhead? And if so, can you explain? Because I personally have yet to kind of get where they're going with
Sure.
that.
I think it's important that you're asking this about Vassar, because I did get, when Vassar was testifying, that he said there was any number of letterheads at the office. And they didn't exactly get the question out about whether there's a letterhead with or without his name, but he almost answered the question in a way to say that there might actually be a template letterhead in the office that doesn't have Ken Paxton's name.
But what's the point? Does that speak to they were staging a coup?
I think that it's, yeah, they're trying to say that they took, and it would be an illegal action to remove his, I mean, that would be tampering with a government record, right?
Yeah.
Tampering with a government document is a criminal offense. It's a state criminal offense. And so I think they're trying to apply pressure to say, hey, you committed a crime. Like, you were so willing to be devoted to your coup that you committed a crime in the process of doing it. And I think it's just they're trying to shore up the conspiracy that everyone was attached to.
And that they were, in fact, quote unquote, rogue employees.
That is correct. That's what the defense is trying to establish.
Who didn't have their story together.
That's right.
Or didn't vet their story.
Right.
That actually raises an interesting point too, and that is, again, I call you up, hey Brad, I believe that I have some information about a crime. Mm-hmm. To what extent am I supposed to go out and investigate the crime myself prior to calling authorities, or is it the work of the authorities to actually do the investigation?
It's absolutely the work of the authorities, and that was, I think, an important distinction in the cross-examination of Vassar yesterday. They said, you went and reported this to the FBI, you didn't bring any hard evidence, and I think he got kind of tricked up on that. So let's be clear about what evidence is, right? Testimony, statements are evidence, right? So when 8 witnesses come into a room and give their version of events about something that happened, that's evidence, okay? I think what Vassar was confused about was that they didn't bring documents. They didn't bring physical evidence to that meeting. He made that clear, and then he got tripped up on cross about it and said no evidence. But no, it's certainly not their job. They've gone to the FBI and said, we have this problem. So now the FBI is going to go investigate it. It's not their job to go get more evidence and bring more things to the FBI. The FBI is involved.
And to that end, well, why don't you just call the Attorney General and say, hey, man, what's up?
Well, I think a really important, you mean the FBI, or do you mean?
No, I mean, there was also the contention that these whistleblowers, these staff members, why didn't you just pick up the phone and call? You had his phone number.
Well,
why wouldn't you have just picked up the phone and said, hey, Ken, how about it?
I think there was a very emotional part of Mateer's testimony where Busby basically asked him that, and he said, I tried. Right. I tried, Mr. Busby. He said he tried. They all tried. Every one of them have testified to multiple different scenarios in which they advised Ken Paxton that he should not go forward with this relationship. We just heard it from the witness on the stand, that he told him he was going to be indicted if he continued down this path. I mean, every one of them tried at different times to come to him at different angles, it sounds like, to warn him that this was a really bad path to be on.
What do you make of this discussion around, he is the Attorney General of Texas. If he has information that perhaps a crime has been committed by the FBI, that he has not only the ability, but also should, in fact,
of course,
investigate those potential offenses. What do you make of that?
Of course, he has every right to do that. He has the right to do it. The office gives him the power to do that through the proper channels, and I think that's where things went wrong, is he attempted to go through the proper channels. Everyone was notified of what was happening, and then there was a muddying of those channels, right? And then there were these ties to a specific individual, which, to say that the AG and the AG's office can't do this on behalf of an individual wouldn't be true, because you can. That's the whole point, right? But I think is when you see the quid pro quo relationship that exists between him and Nate Paul, combined with all these other issues, is where it becomes a problem.
I want to talk about Lieutenant Governor Dan Patrick, of course, who is the presiding officer in this case. Not an attorney, has certainly never been a judge. How do you think he's doing?
Oh, goodness. It's kind of tough to watch his rulings being a trial lawyer, just because they're so flippant. They're flippant. They're not really based on the rule of evidence. Not even consistent. There was a time there during Dick DeGuerin's testimony that he sustained an objection and then he overruled it, and it was the same objection on the same question. And I do like that Dick DeGuerin now is tying him to the actual rules of evidence. He's actually citing subsections of hearsay exceptions and still being ruled against. I think it's a lose-lose situation for Patrick, right? Because if he totally hands it over to someone else, then he's skirting his responsibility, and his voters won't be happy about that. And if he stays doing what he's doing, he's going to be critiqued about his ability to actually rule on rules of evidence. And so it's a lose-lose. I think he's doing the best he can. But it's a political trial at the end of the day. This isn't a real trial. And I do have a comment about that regarding the evidence. I think I think that we're seeing so many more objections from the defense than you would ever see in a criminal or civil trial. And that's because anytime that you're in a trial, criminal or civil, you're worried about what the jury thinks about you as the lawyer and how you are representing your client. You're worried that if you're objecting all the time, that they're going to start to think like you're hiding something, right? You're trying to conceal something and you're doing it in bad faith. But this is so different, right? They know the jurors, and the jurors are clearly biased, and they don't care, right? So they're being as wild as they want, as loud as they want, and they're making.
Yeah, somebody said to me yesterday, it was as though Tony Busby instructed Anthony Osso to just sit there and object.
Right. To everything.
Just sit there and object.
To object to everything as hard as you can, as strong as you can, layer the objections, and we'll see what sticks. And from a strategy standpoint, it is very disruptive to the House committee side to just tell their story, right? Like, we're all here just to hear the story. We want to hear the story about what happened, and they're constantly interrupting it along the way, and it makes it very hard for us to hear that story.
So we talked somewhat about where things go from here. You were saying, in terms of the whistleblowers, maybe you don't call another one after David Maxwell. Maybe you get to others. And just in terms of timing, like how long do you think this is going to go?
I mean, I've seen some people say online, 2-3 weeks. My law partner was actually down there watching the other day, and he ran into a lobbyist who had some connections and thought that it could go for 4 weeks or 5 weeks based on some rumors that she was hearing. So I don't know. And to be honest, my reading of the rules interprets that they could add more time if they wanted to.
Right.
I don't know if they would agree to that, but my interpretation of this says that at any point they can abandon or modify the rules. And so by a 2/3 vote, if they say we need more time, they can get it.
You've been watching closely. How would you sort of appraise the speed of this trial? Would you say things are going fast, things are going slow? I
think they're moving pretty quickly. I think they're moving through the witnesses. They're spending a lot of time on the witnesses, but I think it's moving the way that it should. We're not getting long delays.
And certainly, I hate to put you in this position, but I'm going to anyway. And that is, just in terms of an overall assessment based on the testimony that we have heard, like, how does this shake out? What is your prediction?
I mean, I think based on the evidence and the testimony that's been presented so far, I think that the only real true verdict would be to convict. I do. I think that the evidence is pretty overwhelming so far that these things happen, that the articles could be supported. Now, I will carve out a caveat there, the same that I believe the Senate did. I think that the standard of beyond a reasonable doubt is an extreme burden. And, there's nothing in the Texas Constitution that said that they had to apply that burden. It was actually through the Senate committee that they decided to apply that burden. And that, to me, could be just a little carve out for those Republicans to say, hey, look, I voted in the beginning on these pretrial motions to make this go forward. I didn't agree that we should dismiss up front. But after I heard all this evidence, it wasn't enough for me to convict him beyond a reasonable doubt.
Vincent, thank you so much. The senators have returned to their seats, and Dan Cogdell is back to continue questioning David Maxwell.
Would you agree with me, Mr. Ranger, that in your training in terms of law enforcement, that you are trained that if charges are filed, that ultimately the defendant who is charged will get a copy of the search warrant affidavit?
That's correct.
And the basis for that, to bore us all a little bit, is whether the search warrant affidavit is sufficient or not is often argued by defense lawyers as a basis for trying to suppress the search, an illegal search. That's the typical argument, right?
Yes, correct.
So anybody that fills out a search warrant with any experience is going to know at some point this could well end up in the hands of the defendant or his lawyer. Agree with me?
Yes.
So as a habit, custom, and practice, Ranger, it's true, is it not, that you would not put anything in a search warrant affidavit or really allow anything to be put in a search warrant affidavit that could come back to haunt somebody from a personal safety perspective, right?
That would not be my first choice, but sometimes judges don't give you a choice.
Well, certainly there have to be names, right?
They'd have to be named, yeah.
But they don't have home addresses of the cooperator or where their kids go to school, or that just doesn't happen. Agree with me?
That's correct.
All right, now, this particular search warrant, I'm assuming you've never seen this particular search warrant or the affidavit in support of the search warrant before. This is the first time, I think, you've seen this?
It is.
And did Nate Paul ever indicate to you in any of your meetings with him that he had a copy of the affidavit of the search warrant?
He told me very directly and positively that he knew who signed the affidavit for the search warrant.
Did he what?
He knew who was the officer who signed the search warrant on the probable cause affidavit.
He knew who signed it?
He knew who signed it, yes.
Yeah, okay, all right.
Who the affiant was.
Sir?
Who the affiant
Yes.
was.
And who the affiant was is often discoverable on the search warrant itself, right? Not the affidavit, but sometimes it's on the affidavit and the warrant. Agree with me?
Maybe, but he referred to the probable cause affidavit.
Okay. The affiant is the person who signs off on
That's
the search
correct,
warrant.
yeah.
So what he told you, if I'm understanding you right, Ranger, is that he knew who the affiant was, right?
That's correct.
He did not say, I have a copy of the search warrant affidavit. Rather, he said, I know who the affiant is. Right?
Yes, he did.
Okay. Now, let's get to the matter at hand a little more directly. You received the referral from the Travis County DA's office on, I think, June 10th of 2020. I think Mr. DeGuerin showed you that in your direct.
Well, it was created on June 10th. It went through regular mail, so I didn't get it on June 10th.
Okay. You got it within a few days.
So I got it through the mail.
Okay. But you had gotten an email from Don Clemmer telling you that the referral was on its way, right?
Yes.
And I think that is the point in time where you did what a Ranger Dave Maxwell would do. You Googled around and figured out, at least in your worldview, this guy is up to no good. I don't want anything to do with him, right?
Yes.
And you really began the investigation believing that Nate Paul was a criminal, right?
Not just because of what you said. I felt he was a criminal because of all that I saw.
Fair enough. But my point is, when you began your review, I'm not going to say investigation because it never got that far, okay? So I don't want to step on your verbiage.
Right.
But when you began your review, you began it with the conclusion that this guy is a, quote, criminal and you want nothing to do with it, right?
When I began the review, my thought process was I wanted to see what it was that he had to say.
We'll get there.
And that was what I told my boss, Jeff Mateer, that I would take a look at it. And when I read it, the allegations of conspiracy among so many professionals.
Let me slow you down just a little bit, Ranger, because we're going to get there. But will you agree with me, at least right here, that you didn't exactly go into those meetings with a positive mindset about Mr. Paul, right?
No.
Okay. Now, if I'm understanding it right, the Travis County DA's office decides it's not the appropriate agency to review or investigate this complaint because the Travis County DA's office deals regularly with DPS and with the Rangers, right?
That's not exactly true.
That's part of it.
That's what was in that email, but that's not exactly the case.
Okay, but that's at least what's in the email. You'll give me that part.
That's correct.
Now, does it strike you as ironic at all, Ranger, that they say, we're not going to investigate this because we're too close to the Rangers or to the DPS, and yet they refer it to a Ranger that's in the Hall of Fame that had a 40 plus or minus year career with the DPS? That doesn't strike you as ironic?
I can explain that answer if you like.
Well, first answer my question, and I'll let you explain it. I'll give you that much, Ranger.
No, it doesn't strike me as ironic.
Okay, doesn't sound like Mickey Mantle investigating the Yankees?
Say it again, please.
It doesn't sound like Mickey Mantle investigating the Yankees?
I'm sorry, I still couldn't understand you.
I'm sorry, and I don't know if it's the microphones or what.
All right, really good.
I'm trying to be cute, but I'm really trying to make a point.
Okay.
It's kind of like Mickey Mantle investigating the Yankees.
Okay.
Doesn't exactly jump off the page as an objective review. That's my point.
I would say you talked about my professionalism. I always look at things objectively.
And let me stop you, Ranger. At no time, sir, I may disagree with what you did or didn't do, but at no time am I going to suggest to you that I think you're a liar or you're unprofessional or you're not a man of great character. That ain't where I'm going.
Okay.
We good?
I'm good.
All right. So it was Clemmer that you had the conversation with, Don Clemmer, Ranger?
I did.
And I think you knew him from back in the day at the Harris County DA's office?
Actually, I knew him when he worked for the AG's office because he was the executive deputy over prosecution when I was there in the law enforcement division.
Gotcha.
So we were colleagues at that point.
You were also friendly with him, I guess?
Yes.
So there's nothing in your personal history that would be a source of conflict or tension between you two?
No.
So when you called, when was this first call? Was the call between the time you got the email and you got the referral?
No, I called him after I got the referral in the mail.
Okay. And did you express to Don at any time, Ranger, Mr. Clemmer that is, did you, Ranger Maxwell, express to Don Clemmer, you know, I'm probably not the right guy to investigate this. I don't like Nate Paul. I don't trust him. I think he's a criminal. I think the world of the Rangers. Did anything like that come up in that conversation?
No, my language was much stronger than that.
Okay, but you communicated those thoughts.
I communicated my thoughts in unequivocal terms.
And four-letter words were involved, I'm imagining, Ranger?
I probably won't use the same language in the court that I'd used at that day.
I wouldn't ask you to, certainly. There may be some court somewhere, but this is not the one I'll ask you to use the language in. All right, so it is true, is it not, Ranger Maxwell, that typically as the, are you deputy director? Are you director of law enforcement? Give me your title again at the...
Director of law enforcement.
Okay. Typically as the director of law enforcement, Ranger Maxwell, you didn't often get personally involved in investigations, right?
Yes, I oversee them, and sometimes I actually personally get involved.
But that's my point. The majority of the time you oversee.
Yes, absolutely.
Okay, and you certainly would you typically, Ranger, assign something like this if a player like Nate Paul wasn't involved? Would you typically assign a referral like this to someone lower than you on the food chain?
I would assign it to my major who was over special investigations and have him sign a team to investigate the allegations.
And I think you told us the reason why you didn't assign it anyplace else, but regardless, you kept this one for yourself, right?
I did.
All right. Now, you got the referral in mid-June, right?
Yes.
And you had the first meeting with Nate Paul and Mr. Wynn, Michael Wynn, July 21st.
That's
right?
correct.
Now, let's set the stage in terms of, forget about how your thoughts about Nate Paul, forget about your thoughts about Paxton's involvement with him, and focus, if you can, on just the otherwise oddity of having a conversation with a fella who is under investigation for federal offenses, right?
Yes.
And he comes in to you a known quantity, shall we say, in the law enforcement community, and he and his lawyer are sitting down with you, opening themselves up to asking them any question you want to, right?
That's correct.
I'm going to go out on a limb here, Ranger, and suggest that despite your storied career, something like this may not have ever happened. Would you agree with me?
Possibly.
Okay. Now, and when I say something like this never happened, let's just say I don't know many defense lawyers that would have taken the same position as Michael Wynn and walked their client into that meeting. Agree with me?
Okay.
Now, before that meeting started, did Ken Paxton ever come up to you, did General Paxton, Ranger, ever come up to you and say, hey, I want you to give him immunity. You can't use those statements against him. He gets a free pass for anything he says. I mean, there was no condition put on your being able to ask Nate Paul questions. Agree with me?
That's correct.
And likewise from Mr. Wynn. He never likewise asked you, hey, everything is off the record here. You're not going to go anywhere. That didn't happen either.
No.
In fact, I think you told, was it Mateer, that, yeah, I'll have this meeting, and what I'm going to do is if they say anything that incriminates them, I'm going to mail it right over to the U.S. Attorney's Office, right?
Well, no, I was going to contact the FBI
Okay.
and give that information to them. I also told General Paxton the same thing.
Okay. So the point is you went into it with the mindset that if Nate Paul, or I guess even his lawyer, said anything that was incriminating about any criminal activity, that you were going to pass that information on to the appropriate agency.
Yes.
Right? And it's true, is it not, Ranger, that never happened. That is, they never said anything that incriminated them or that you passed on to another agency, right?
Right.
I want to make sure, I don't know, frankly, Mr. President, I want to offer, if it's not in the House Board of Managers Exhibit 149, which is the video of the 721 interview, as well as the Board of Managers 151, which is the transcript of that same interview.
No objection.
Okay. And likewise, while I'm doing that, I want to offer into evidence 156 and 158, which are the video of the August 5th interview that Ranger Maxwell and Mr. Penley had of Mr. Paul and Mr. Wynn, as well as the transcript, which is 158.
Okay, let me.
No objection.
We're looking at those numbers.
I'm looking at.
Yes. Yes, Mr. DeGarren?
Oh, no objection to the introduction of those, of the video, audio, and transcript.
Thank you.
Make sure I have the numbers right. Hold on, Counselor.
Yes, sir.
We're going to enter 151, 149, 156, and 158 into evidence.
Yes, sir.
No objection. Show them being entered into evidence. Go ahead.
All right. Now, Ranger, do you still have the three little...
I do.
And I'm not going to try to give you a pop quiz and ask you if every single word that I'm saying, I hope you'll trust me far enough to say if I say it, it's in there. But if you want to check me, please check me and I'll point you to the citation, okay? I think early on in your House interview, which is also in front of you, I think that's the orange folder, that you said his main allegation, when you were, to back up, when you were being interviewed, I jumped from your interview of him to their interview of you, but in your interview with the Board of Managers, you said his main allegation of why he didn't like the raid that they conducted was he was alleging that the copy of the search warrant had been altered, right?
Right.
And that's true, right?
Right.
That's true in terms of that was what Nate Paul was claiming to you, right?
Right.
And that at some point in the first interview, I think Nate Paul told you, Ranger, that he didn't even think they had a search warrant for at least one of the properties being searched, which was the storage unit. You recall him telling you that?
Yes.
And he went way deep. That is, Nate Paul went way deep into metadata, right?
Yes, he did.
Do you know as little about metadata as I do?
Maybe less.
All right. Metadata, at least as far as you and I know, is sort of the fingerprints that any electronically created documents leave.
Yes.
Now, you said that, and I hear you, you said a couple of times to Mr. DeGuerin that his accusations were so ridiculous and so conspiratorial, I'm characterizing, that it was just absurd to you to even hear him, right?
Right.
Would you agree with me, Ranger, that Mr. Wynn, his lawyer, through both of those things, did say words to the effect, Ranger, that he doesn't think they're evil people, maybe they just relied upon poor information and they don't know how to back out. You remember that verbiage that Mr. Wynn?
No.
If you will look, Ranger, on page 63, line 22 of the 7/12 interview, and for the color-coded challenge, that is going to be in the green.
In the green, he's looking in the orange right now. The green or the
David, Ranger.
Ranger?
Look, the 7/12, which should be in the green folder.
Yeah, on the green folder.
Yes.
Yes, sir. I'm sorry, 7/21. If you'll look on page 63.
63, okay.
At the very bottom of 63, you recall Mr. Wynn telling you, I'll wait for you to get there, Ranger.
Okay.
At the bottom of 63, Ranger, Mr. Wynn says, that's the problem. I don't think they're evil people from the core. You see that?
Well, mine doesn't have all the words.
Yours doesn't have all the words?
It says, that's the problem. I don't think they're, and it's blank.
Well, the next line is, I don't think they're evil people from the core. You see that?
Right.
And make sure you keep that microphone close to you, Ranger.
Sorry.
No, sir, that's fine. And then the next page, it says at the top of page 64, Ranger, they listened to the wrong people and it got it wrong and they just can't come forward and say, oops, right?
That's what he said.
Now, again, not suggesting that you should buy that description, but that is certainly what Mr. Wynn is telling you in this first meeting, right?
Yes, that's right.
Okay. Now, you told, Ranger, this jury in no uncertain terms that you never had any intention of ever investigating this. It was nonsense from the beginning, and you just wanted nothing to do with it. Again, I'm paraphrasing what you told us, right?
That's correct.
Ranger, it's true, though, that you never said that to Mr. Wynn and Mr. Paul.
That's correct.
Okay. Instead, what you told them, and this is probably the sly investigator coming out in you, I don't mean to diminish your skill set, but what you told them was, maybe I can get some answers for you, right?
Right.
And you said, I can look at this and talk to the DA's office and see where we get, right?
Right.
Told them, I'll look at the metadata just to see what our people tell me about it, because I pay a lot of money to those people to get them trained, meaning your metadata people.
That's correct.
Right?
Yes.
And I will sit down with the DA, and if we have something, we do. And if we don't, and they say no, that's as far as I can go, right?
Right.
So, and again, I think I get the reason why, but what you're telling us about your opinions about their story or their position is certainly different than what you were telling them, right?
Say that last part.
Yes, sir. What you're telling us, your opinion of their description of what may have happened, your opinion that you shared with us is a very different opinion than what you shared with them. That is Mr. Paulins. Okay.
Absolutely.
Now, did you, though, early on, Ranger, tell them that it was up to the DA's office, ultimately, to accept charges or not?
Yes.
Okay. So when Mr. DeGuerin had the DA's office recuse themselves, and that's a term of art we'll probably get to, but when he said, have they recused themselves, you said yes, but you certainly never told or suggested that to Mr. Paul or Mr. Wynn, that is, that the Travis County DA's office had recused itself, right?
I go back to the protocol I testified in the first place, which is I require.
Ranger, I can't hear you. And I don't mean to step on you, but I want to hear you.
I go back to my first statement when we talked about the protocols I have in place, that I require a letter from the DA in that jurisdiction that he'll either prosecute or recuse himself and let us prosecute.
Okay. And correct me if I'm wrong, but I don't think you ever got a letter from the DA in this case that they had recused themselves. Margaret Moore never wrote you a letter and said, we are recusing ourselves from this investigation.
There is no investigation at this point.
Okay.
There was not going to be an investigation, and there's nothing for them to review.
Okay. I hear you. But if they didn't recuse themselves from an investigation because there was no investigation, they didn't recuse themselves from anything.
No, not the investigation. They had to if they wanted to recuse themselves and have us prosecute.
Yes, sir.
They either have to agree to prosecute the case or recuse themselves and allow our people to prosecute.
And neither one of those things happened, if I'm understanding what you're saying right now.
Neither one were going to happen, no.
Gotcha. And that's my point.
Yeah.
That didn't happen. And maybe you know this and maybe you don't, but I'll go out on a limb and ask you. Do you know sort of the conditioned precedent for a prosecutor pro tem? Do you know what that term means? And you may not, Ranger.
No, I'm not going to try and define that.
Sir?
I won't try and define that.
Fair enough. Now, what is the web pass system? The web pass system.
I'm not sure.
Well, as I understood it, and I could be wrong, Law Enforcement Division maintains what is called a web pass system, which has an offense report or a case file in it.
I'm still not understanding what that is.
Well,
what's the purpose of it?
Let me just put it this way. You never created any memorandum, right?
No.
No memorandum of an interview, right?
No.
No report of an investigation or a review?
That's correct.
No note to the file, right? You didn't initiate so much as a post-it note, if I'm understanding you right. I'm sorry if you can't hear me. I think you're the only one in the world that can't hear me right now, Ranger. But you didn't even create a post-it note about this case,
I did not take any notes or even create a post-it note about it. That's correct.
Now, Operation Longhorn. May I have just a minute? I approach Mr. DeGuerin. I think I showed you this picture.
Yes, you may.
I've seen what he's offering, Your Honor, and my objection is that it's not only, if it's offered for the truth of the matter, we think it's false and we don't want it, so we object to it. But I don't know what the offer is.
Well, I thought at the break that he had told me he wasn't going to object to it. Whatever, that's fine.
Go to your mic so we can all hear the conversation.
From my understanding with Mr. DeGuerin at the break, he told me he wasn't going to object to it. But that's all right. People can change their mind, Dick. I've been married a few times. It's okay.
Mr. DeGuerin?
Let me clarify that. I told him I didn't object to it, but I don't agree that it should be admitted for the truth of the matters stated. It's something that was prepared by Nate Paul and his lawyers to show to Mr. Maxwell. We think it's hogwash, but it can be admitted.
Is that an objection, Dick?
Yes, that's an objection.
Objection hogwash?
Objection hogwash.
All right. You best not sustain
Wait
that
a minute.
one, Your Honor.
Which one of those rules is that one, Mr. DeGuerin? 802 or 803? Got them all up here.
803.75.
If it's not, we're writing a new one. Okay.
It is not, Mr. President, being offered for the truth of the matter asserted, but only to show that Ranger Maxwell and I think Mr. Penley actually were presented with a copy of this. We're not suggesting it's true or it's the letter of the law, but only that it was given to them. That's the limited scope of the offer, all right?
We'll overrule.
All right,
We'll overrule. Because it's not being offered as truth as the matter asserted.
Mr. Arroyo, are you with me? And it's marked, I don't think I said this for the record, Your Honor, it's AG 1005. So we're offering AG 1005. And Ranger, can you see that screen in front of you?
Yes, we're up on screen.
Thank you.
This is your exhibit?
Yes, sir. It's the electronic copy of what I'm holding in my hand, Judge.
For the same ruling, we'll admit this into evidence.
Yes, sir. All right. Mr. Arroyo, could you go to the first page? Next page. Yep, next page, please, Eric. And if you could highlight the first sentence for me, please, and blow it up.
Can you go back to the microphone, please?
Oh, I'm sorry. It's a big room. If you could blow that up for us, Eric. It says that there were 3 search warrants that were executed simultaneously on Wednesday, August 14th. You see that, Ranger?
I do.
And if we'll go down, Eric, to the second to last paragraph, it says, since the search warrants were sent as PDF files via email, after the searches, we were able to analyze the metadata of the PDF documents that were emailed, right?
I see that.
And finally, Ranger, it says, according to the filings with the court in the Western District of Texas, each of these search warrants was signed and issued by Judge Mark Lane on Monday, 10 a.m., August 12th. But if we look at the first sentence and the last sentence, what they are alleging is that the search warrants were, per the filings, per what you and I could see if we looked at them, the search warrants would have been issued at 10 a.m., but on a Monday the 12th, but in reality, the documents were created on Wednesday the 14th, 2 days later, right? That's their claim.
No, what it says is that the 3 search warrants that were executed simultaneously on 9 a.m. on Wednesday, August 14th.
I got you. And the filings say, you're right, I stand corrected. They were executed on
the 14th,
right? And then on the next page, Eric, if we'll go to the next page, and I think that were there a total of 6 warrants, Ranger?
Well, there were 3 warrants that were executed. They had 3 more warrants that they did not execute.
Gotcha. So you spent a long time listening to Mr. Paul's description and Mr. Wynn's description of this Contigo, this search of a storage facility. You spent probably 30, 45 minutes listening.
Yes.
And the net of their suggestion to you, Ranger, was that the search warrants for that facility were created after the search, right?
That's what they're alleging.
Okay. And according to them, and again, I don't know metadata, but according to them, Ranger, it was through the forensic analysis of a PDF that was sent by Alan Bowie to one of their prior lawyers, Chuck Meadows and Aaron Borden. That's how they say they broke the code on this. You with me?
I am.
And you agree with that summary?
What's that?
You agree with the summary that that's their claim? I'm not asking you to believe
claim.
Fact, that's their claim. If we go to the next page, and again, they are saying that the document metadata reveals information that is inconsistent with looking at the documents on their face. You with me?
Mm-hmm, I am.
Okay. And I'm not going to bore us all, but this is what they gave you back on August 5th, right?
I see it.
And they also gave you a thumb drive, correct?
Yes.
Now, I think one of the things that would be a condition precedent was whether or not a condition precedent for involvement by the Attorney General's office of the state of Texas would be a violation of state law, right?
Okay, yes.
I mean, you can't investigate, investigate, or prosecute federal cases, right?
That's correct.
Will you at least agree with me that if what they were saying was true, that these actions by federal prosecutors would be a violation, if they were true, a violation of state law, right?
The state law, and this is one of the only reasons why I agreed to hear him out, was falsifying a government document would cover a federal document.
Yes, sir.
Even though we don't have jurisdiction over anything else about it.
Gotcha. And I think we're saying the same things, you probably better than me, but if a federal law enforcement agent or prosecutor or judge or whatever, if they knowingly entered false information into a document with the intent to deceive someone else, not only would that be a federal crime, it would be a state crime. I think it would be tampering with governmental records, right?
That's correct.
Now, would you agree with me, Ranger, that despite your concern or belief or hope that Mr. Wynn or Mr. Paul would say something incriminating or say something that would cause them exposure criminally, neither Mr. Wynn nor Mr. Paul ever ask you to do anything illegal?
Yes, they asked me to interfere with a federal investigation, which is absolutely illegal. It's also obstruction of justice.
Show me, Ranger, in the first hour or the second 2 hours on the investigation or the interview of July 21st or August 5th, you've got the transcript there for both of those.
Counselor, you are showing me the evidence right here. This is it's a map of how he wanted the investigation to be done and to have the AG's office follow how this was to be investigated, along with targeting 6 individuals.
Okay, where does he, excuse me, Ranger.
Go through it and you'll see it.
Show me.
It'll show it. I don't have a copy of it.
I'm sorry?
I don't have a copy of it.
You do. You've got a copy of the entire transcript of July 12th, Ranger?
No, I'm talking about the document you have up on screen right now.
Show me, Ranger, where they say you reviewed the transcripts of the July 12th interview and you have reviewed the transcripts of the August 5th interview. Show me the language where in either one of those interviews, Ranger, that they ask you to commit a crime.
They're not in the interviews, Counselor. They are in the document you're looking at right now. He lists 6 people as a person of interest to be targeted in this investigation.
Where does
right
it ask?
It's in Operation Longhorn.
I'm sorry, I'm talking over you. I apologize, Ranger. Where in this PowerPoint, show me, Ranger, where in this PowerPoint that Mr. Wynn asked you to commit a crime or Mr. Paul asked you to commit a crime? Where?
Objection, Your Honor. He doesn't have a copy of this in front of him. May I give him my copy so he can answer that question?
Providing a copy now.
No, I don't.
My apologies. I thought you had one.
Your Honor, may we approach about some
Yes, you may.
addresses?
Yes, you may.
And we've been listening to continued testimony now on cross-examination of David Maxwell. He is a former Texas Ranger who worked as the director of law enforcement for Attorney General Ken Paxton's agency.
Really been impressed with his answers. He is a sharpshooter, to say the least, when it comes to his responses, and not really having, much to say to the defense.
And we have Brad Vinson, local Austin attorney, with us this afternoon. Brad, what is your impression about how things are going this afternoon?
I really don't think that Goudeau is scoring any points at all with this witness. I think that he's holding his line exactly as we expected that he would, and Goudeau's not getting anything by him that's helping the defense in any way.
What's Goudeau going for here?
I really don't know at this point. He spent a lot of time bolstering him as a witness to then, I thought, kind of bring apart his credibility, and I think this might be a bit of what they're debating at the bench right now.
They're saying right now that they're going to go on about a 5-minute break. They're going to allow Eric Arroyo, we've learned today is his last name. That's the AV guy, if you will, the AV tech for the defense. They're going to give him some time to pull up these documents that they're asking about, kind of what they're talking about here. Let's take a step back for our viewers about some of David Maxwell's testimony.
Yeah.
It was quite damning to hear from him. You spent the past few days hearing from lawyers, and they're speaking as lawyers, and they are answering very eloquently.
That's actually a really good point. Yeah.
What
David Maxwell is not a lawyer.
David Maxwell is not a lawyer. He is sort of a salt of the earth Texan. A famed, in the Hall of Fame, a famed
right.
Texas Ranger. And so then my question for you, Brad, is about the timing of potentially having us end, potentially having him, if they can, stretch it out and him be the last witness on the Friday before the jurors go on their weekend break, for him to be the last voice that we hear. How powerful and how effective of a strategy do you think that would be?
Right, I think it would be perfect. And in fact, I think I commented earlier, the way that he ended on direct was amazing. The last question was, I didn't think it was wrong because I was doing something right. And you should never be in trouble for doing something right. And so I think ending with this witness, both on Friday and potentially ending with this witness as the last whistleblower witness, would be advantageous for the House committee side before getting into other issues.
You certainly have had to call witnesses before. Talk to us about the strategy of the order of which you call a witness.
Sure. I look at every facet of trial as starting powerfully and ending memorably. You always want to come out with a bang, and you always want to end in a way that people remember what you were talking about and what happened. And so if this is the last one, I think everyone's going to remember this guy for sure.
And you were saying earlier that if you were calling the shots here, you're thinking you would be done with whistleblowers at this point, that David Maxwell has told the story.
That's right. I think he bookends it perfectly, right? You heard from the people at the top, you heard from the lawyers, like you said, and now you heard from a retired law enforcement individual who spent a lifetime devoted to Texas.
A half century.
48 years.
It's really an incredible career in any profession.
And honestly, didn't necessarily want to end that career at 48 years. Would still likely be in law enforcement to this day had he not been fired from the Attorney General's office.
And Brad, we've sort of talked about that, how important it is, and I'm interested in your perspective on this too, to infuse emotion with sort of the more factual disclosures and having these witnesses in many ways be sympathetic characters.
Of course, that you always want some emotion, right? You don't want too much, right? I've had witnesses before that turn into a sobbing mess, and you actually have to stop and say, this is a very serious proceeding. Let's back up and think about what we're doing here. But a little emotion, I think Vassar and the other witnesses showed emotion appropriately at the right time and in the right amount. And then you've got this witness who is just playing it just right down the line. His answers are yes, no, How
I
did. You
did.
know? It was me. Yeah. Like he's keeping it so simple. He's keeping it so to the point that it's clean. It's clean. It's easy to understand. It's easy to follow.
I think one of the things that was really striking to me, without him saying it, but sort of with him saying it, when we're talking about the way in which he was fired from the AG's office, sure, and sort of the disrespect I think that he must have felt, because he was someone who is so pointed and so sharp about what they are telling us and not giving us a lot of detail to point out that the time frame that he was told to be there at 1,
left sitting in the lobby,
he was left sitting there for hours, for someone to say, I always show up early. I was supposed to be there at 9. I got there early. They didn't come in to see me until 9:45. So almost sort of this disrespect of time. And I know that you are a legal guy and not necessarily a politics guy, but we're all politics nerds here in Austin. The fact that you're having this testimony from someone who is a respected member of law enforcement with these Republican senators who, Tony has made the point, the trial is for the Republicans. This is a trial for them because they're going to have to decide. You stand on backing the blue. Right. How can you not back this guy?
Right, I agree with you totally. I think that a vote of not guilty is a bit of a slap in the face to this witness. And I think to your point a minute ago about his firing, he doesn't strike me as this kind of guy that would ever complain about, having to sit somewhere and wait somewhere and deal with something. So for him to come out and talk about that in a way that clearly shows he was disrespected, I think means a lot. Because I don't think he's the sort of guy that would actually get into all those little things, that he sat there for that much time and waited all that time. But it was so disrespectful that they treated him that way. And you're right. I think for the Republican senators that are out there, a vote of not guilty is a bit of an issue for their bullhorns in backing law enforcement.
Brad, I wanted to ask you as well, not that the verdict will totally be based in law and legal definitions. We know that despite a constitutional oath, it is inevitable that politics will likely be infused in the vote among some of these senators, particularly the Republican senators. But the standard, the burden of proof, can you just talk about, according to the rules, what that burden of proof is and what that means exactly?
Sure. So the burden of proof is beyond a reasonable doubt in these proceedings, and that was agreed on by the Senate committee. There's nothing in the Texas Constitution that defines what the burden of proof is supposed to be in an impeachment proceeding. So I think that it's kind of a backdoor for some of these Republicans who wanted to say, hey, look, I'll get this burden this high, I'll vote to allow this to go forward, and then once we hear all the evidence, I can say, hey, voters, I brought you all the evidence. I thought we needed to hear it all, but when I compared it to that burden of beyond a reasonable doubt, it was just too much. There is no actual definition of beyond a reasonable doubt.
Well, that was going to be my next question.
In Texas, there's no statutory definition of it. It's not defined in case law. Other states do define what beyond a reasonable doubt means, but Texas does not.
But it is the burden of proof in criminal cases.
It is the burden of proof in criminal cases.
And they could have chosen preponderance of evidence, right?
Or I think the more appropriate burden would have been clear and convincing evidence, which is between preponderance and beyond a reasonable doubt.
If you've done jury duty before, they show you the chart and the step chart, and they talk about, what it takes to remove a child from their parents' custody, which is not beyond a reasonable doubt.
But it's clear.
And so this goes beyond that. There's something else that I wanted to point out when you were mentioning impeachment. When we think about the latest impeachments we've seen, which were that of former President Donald Trump, we think about the bar for impeachment and conviction being high crimes and misdemeanors. That bar does not exist in Texas. That's right. Not what they don't have to prove that.
Right. That's right, and that's what's troubling about this balancing act, right? Because you say, what is really at issue here? Ken Paxton's not going to prison as a result of this proceeding. He's not losing constitutional rights. He's losing his job. Right, which is why you would question whether you should apply it beyond a reasonable doubt. But then you also have to balance that against the electorate, right? 4 million people voted for him,
which the defense has consistently reminded us of.
That's right. So you have to balance those two factors, like which burden should be, and the Senate decided that it would be beyond a reasonable doubt.
And it's interesting because also when you look at the articles, and because the articles, I think you have to look at beyond a reasonable doubt, or perhaps why they went there. For instance, the article related to giving Nate Paul classified documents or sealed law enforcement documents.
When you listen to information from a file,
when you're listening to him say that,
Exhibit 1000
compared to you had Sorry, obviously Lieutenant Governor Dan Patrick is speaking in my ear, so that's why I'm pausing here. But
he was just saying, by the way, in case you couldn't hear, they're doing some redactions on some documents before submitting them.
Yes, removing some personal information for some folks before they put it in. When we think about the article of impeachment, for example, that alleges that Ken Paxton gave or was instructing his office to give Nate Paul, sealed, non-public documents. But then you have the defense saying, well, the statute of limitations for them to respond had worn out, and the FBI therefore had to do it because they're required to do that. I think that's where you start to see, well, is there doubt there? Is there doubt there that that's what the case was? Right.
And again, you were talking about the scale, the burden, the stairs. Something that I often tell juries is you can be clearly convinced that this crime occurred or that these elements have been met, but you could still have a doubt based on reason and find them not guilty. Right? Think about how powerful that is when you're talking about the burdens that exist and the caveats on finding that there's reasonable doubt and all of these things. And
as we've talked about, if you walk into it with an inclination that politically you would like to find Ken Paxton not guilty,
right,
there you have it.
That's right.
So then this is something I've wanted to ask an attorney, but you're doing it for 16 articles.
Right.
So you try one crime at a time.
Right.
Generally it's, can you find out for one thing? You've got to find out for 16 things. I mean, I think this was intentional by the House to intentionally do 20 articles of impeachment to say you may side with him on this one, but can you side with him on this?
Right, and we do try some felony cases sometimes that have multiple counts on a felony indictment.
Not 16.
It makes it very hard to win, right? But I think that what the defense is trying to do is trying to cluster those together, right? And I think we talked about this a little bit earlier. There are 4 of those articles that are just kind of catch-alls. They don't really have many elements. They're just like, did you think or does it sound or smell like you did something wrong? Those 16 through 20 are all just like, does it seem like something bad? The other ones are related to specific things, and a chunk of them are related to the whistleblowers. And that's why they're targeting each of these things. The whistleblowers, the quid pro quo regarding the home, the situation regarding the mistress we'll get into. But I think they're trying to group them together so that they can kind of blanket, blast each of them from the defense side.
So you were saying that potentially if you were the House prosecutors, you would call former Travis County District Attorney Margaret Moore maybe even next. And I'm just curious about why her and what you would ask her.
I think it's important to get into these lunches that occurred and why the DA office, kind of came back and said we're not going to be involved, right? And to get some insight into why they said they weren't going to be involved. I think that could tell us something that would be important for the case. Particularly
if they were looking themselves into Nate Paul.
Right. And they're the DA's office. They're the local DA's office. And there's always a little bit of, hey, this sounds kind of like fun and sexy. We should be involved in a major investigation that involves the FBI. Maybe there's something there that could, put me on the map as the district attorney for my next election. But the fact that she said no kind of makes you think, well, that was something I wanted to, keep my hands clean of.
Something else you mentioned about these lunches, and this was something that they got into yesterday.
Members, if you can retake your seats.
I say that, but they're asking the jurors to take their seats. So I guess you're just going to have to keep watching KVUE Plus in order to find out what exactly I was going to ask Brad next.
Okay. Yes.
We're going to.
I think they both have a page out there.
All right. We
ready to resume.
We good, Ranger?
Yes.
All right. So what happened there is that someone noticed that there were names and home numbers or home addresses and telephone numbers. We've redacted those names, right?
Yes.
Now, what crime is Mr. Wynn or Mr. Paul asking you to commit by tendering this PowerPoint to you?
They entered the PowerPoint and gave it to us to map out how they felt our investigation that they wanted to be created should go.
Okay. We have a transcript, do we not, of exactly what they said?
Transcript of?
Exactly what they said when they were meeting with you on August 5th when they gave you this PowerPoint?
Yes.
Okay. And you've reviewed that transcript, you say?
Yes.
And where in the transcript, what words do they use to describe to you that they desire a crime to be committed?
They obviously did not say that they wanted a crime to be committed. What they wanted was an investigation.
Okay. And your position, Ranger, is two private citizens coming in and asking for an investigation into whether or not search warrants were illegally created, that asking for that investigation is a crime?
Following through on the investigation is a crime.
What crime would it be to investigate the legality? If that's a crime, I'm going to be on death row. I investigate the legality of search warrants all the time. That's what I do. What crime is it, Ranger, for them to ask you to investigate the legality of a search warrant?
The only purpose...
No, sir. Objection non-responsive. What crime is committed?
Sustained.
Objection, he didn't allow him to finish so we could see whether it's responsive or not. I believe it was going to be responsive. Objection to interrupting the witness.
I'll
Overruled, sustained, but
I'll ask again. And I'll
ask again, take a pause.
And I'll calm down.
And you can raise the mic too.
And I'll calm down and raise up. Okay. I'll try again, Ranger.
Right.
Even at my age, I get excited every now and then. What crime is committed, Ranger, by them asking you to investigate the legality of a search warrant? What crime is that?
In my professional opinion, to create this investigation and follow through it would be obstruction of justice and interfering with a federal investigation.
Okay. In fact, doesn't Mr. Wynn say over and over and over in the transcript he does not want to interfere with the federal investigation? He does not want to obstruct justice? Doesn't he say that?
He does.
Okay, so the fact that he's saying he doesn't want that done, even though he says he doesn't want that done, you think it's a crime because?
His actions belie his words.
Okay. Well, you are Dave Maxwell, Hall of Fame Ranger. If they would have committed that offense right there, literally on videotape, the Dave Maxwell I know would have stuffed and cuffed him right there. You would have arrested him, right?
No.
Okay. All right. In fact, Ranger, what did you tell him?
I told them that what I said in the beginning, that we would have the forensic people look at the metadata, and they promised to give us all the documents they had in order for us to do an examination.
Let me try again, Ranger. Instead of saying, you've committed a crime, I'm going to arrest you, what you say on page 143, line 24, is we're going to look every which way into this, right?
That is exactly right as far as the metadata.
Okay. Mr. Penley says, quote, we're going to look into these allegations, right?
He may have said that.
Okay. Mr. Penley says, thank y'all for coming in today. We appreciate it. Thank you for the handout and for the documents. We'll look into this. Are those the Mark Penley's an experienced prosecutor, right?
Yes.
He was with the U.S. Attorney's Office in the Northern District of Dallas Division by my recall 15, 18 years. He's not a newbie.
Something like that, yeah.
Do those words, Ranger, sound like the words of an 18-year experienced federal prosecutor that believes a crime has been committed?
No.
Thank you for the handout and for the documents. We'll look into this.
What is your question about what you just said?
My question is, do the words spoken by Mr. Penley suggest in any shape, form, or fashion, Ranger, that he, Mark Penley, believes that a crime has been committed in his presence by the tendering of the very documents we've just discussed?
Absolutely not.
Do you think Mr. Penley's a pretty straightforward guy most of the time?
I'm sure he is.
Well, you worked with him, didn't you?
Yes.
I assume, Ranger, that if he exhibited any characteristics of deceit or deception, you would have picked up on him.
Who would have picked up on the deceit?
You, Hall of Famer Dave Maxwell.
How I answer that is that he and I both knew that the only thing we were going to do was look at the metadata, period.
Okay. Well, since you know what he knows, did he think he'd been asked to commit a crime, Mr. Penley?
Mr. Penley did not believe that a crime had been committed by these officers or the magistrate or the U.S. Attorney's Office.
My question probably wasn't a good one, Ranger. Did Mark Penley believe that Mr. Wynn and Mr. Paul, by asking for this investigation, did he think that was a crime by the simple asking of the legality of search warrants to be investigated was a crime?
He believed, as I did, that if we followed through with what they were asking, it would definitely be a crime.
Okay. And that's why he continued to work on this case? That's why he continued to do an investigation? That's why he told Ken Paxton, I've got more work to do. There's more things I need. I need to do some more research. Does that make sense, Ranger?
I didn't tell Paxton that.
No, he did. Are you aware of that?
Who did?
Mark Penley.
Oh, I don't know what he told him.
Ranger, when is it, sir, that you first heard the name Brandon Kamek?
When I was on vacation in Colorado.
And I think Mr. DeGuerin had you in late September.
Late September. I was traveling to Colorado on the 26th of September, 2020.
Okay. And you learned of that name how?
Through Mark Penley.
Okay, so do you have an independent recall, Ranger, of the date of that? Like 25th, 26th, 27th, just ballpark it for me.
It was on the 26th of September 2020 when Mark Penley told me about what was happening with Kamek.
Okay, so Penley calls you, you're in Colorado at the top and you got to come down and that's...
Well, actually I was driving at that time, so I had him on speakerphone.
Okay, but anyway, you're in Colorado,
right.
He's here.
Right.
And he's upset and annoyed, whatever, because Brandon Kamek has been hired.
I think at the time he had not been hired, that on that particular date, he had a meeting with Ken Paxton, and Ken Paxton tried to get him to sign the EAM so Kamek could be hired.
Let me slow you down.
Okay.
I'm stepping on pronouns.
All right.
When you say he tried to get, who is he? You just said that
he tried, Ken Paxton.
Yes, sir.
Tried to get Mark Penley to sign off on our EAM, which is a protocol that various people have to sign in order to hire, spend money, that type of thing.
We've unfortunately heard a little too much about an EAM. But for purposes of this exchange, Ranger, are you aware that the Attorney General has the authority to hire outside counsel himself, statutorily?
The way the system works is...
Non-responsive. Objection, non-responsive.
Sustained.
Are you aware, Ranger, statutorily, the Attorney General has the authority for he himself to hire outside counsel?
I was told by...
Yes or no? Are you aware?
I do not know that's a fact, no.
Okay. You don't know one way or the other?
It's not my bailiwick.
Yes, sir. All right. Now, when we talked earlier, Ranger, about some potential mistakes that you may have made when you met with the House committee about your recollections, and to be fair to you, Ranger, this was a meeting this year in February, right?
Yes, it was.
And what had happened back at least 2 years ago, maybe
Yes.
2.5, right?
Yes.
So I'm not carping at your memory. I just want to make sure we're all on the same page now as to what's accurate and what's
Okay.
not. Okay. Do you remember telling I think we've already discussed sort of globally, at one point you told the House committee that Drew Wicker delivered documents in a back alley in the dark of night, right?
I did say that.
And I'm the last person, Ranger, to strike out at another about hyperbole, but that's what that was. That was just an exaggeration on your part, right?
No, it was exactly what I had been told by numerous other people. I had no direct knowledge.
All right. So who was it, Ranger? Who was it, Ranger, that told you that Drew Wicker delivered these documents in the dark of the night in a back alley somewhere? Who told you that? You said you were told that by numerous people, so give me two.
Counselor, in being very honest with you, there's probably 5 or 6 people who told me that in passing, and I couldn't tell you who it was. It's 3 years ago.
Okay, well, if it's 5 or 6 people that told you that, can you give me one of them?
If I testified today who it was that gave me that information, I would not be able to say honestly that that person did.
Okay. Well, you certainly told the House committee that, right?
I absolutely did.
And when was it, Ranger, that you decided that that statement to the House committee was incorrect?
I didn't know whether it was correct or incorrect. I passed it on to the House. That's their job.
Let me back up, Ranger.
Yeah.
I thought 2 hours ago or whenever it was, when you and I started this dance, sometimes friendly, sometimes not so friendly, I asked you if there was anything in reviewing your statements to the House managers that you believed was inaccurate, and you pointed out this very statement, that is the Drew Wicker dark of night back alley statement, and you had indicated that you had, I think, come to that conclusion after meeting with either Mr. DeGuerin or Mr. Hardin. Is that right?
Yes, it was one of my attorneys asked me, did I make that statement on that date? And I said yes, that I was passing on information that I received from someone else.
Okay.
But I had no direct knowledge.
Right. So are you relying upon Mr. DeGuerin or Mr. Hardin now for the truth or falsity of something?
I'm not sure I understood your question.
Okay. Well, you told the House back in February that Drew Wicker, dark of night, back alley. Now you're saying that's a mistake. When did you determine it was a mistake?
I don't know whether it's a mistake or not. I'm passed on the information. I was asked by our attorneys, did I say that? And I said yes. And I explained to them that I passed it on to them to investigate it.
Okay.
So I don't know what Drew's testimony would be or would not be. I don't know the truth.
So you don't know if what you were saying to the House managers is true or not?
What I was saying to the House managers was that somebody needed to talk to Drew Wicker. That was my only purpose in bringing it up.
Well, but when you tell the House managers your statement, you would agree with me, Ranger, you don't say, I heard from 5 or 6 people that his travel aide, who was with him at all times outside the office, went with him to have meetings, and also in one instance carried documents and gave them to Nate Paul in a dark alley one night in the middle of the night. You don't say you heard that from 5 or 6 people. You say that as a fact, right?
In my mind, I said it for them to be a lead to go talk to Drew Wicker.
Okay.
I didn't say it as a fact because I have no personal knowledge.
You're saying you didn't suggest you had personal knowledge of that?
I do not have any personal knowledge about what Drew Wicker would or would not testify to. I was relaying what I was told by others so the committee could find Drew Wicker and find out what the truth is. It's part of an investigation.
So how do we know, Ranger, when we look at your statements that have been made to the investigating committee, how do we know that those are statements based on your own personal knowledge or based on something that you've heard?
I will certainly tell you if you ask me.
Well, you didn't tell them. You didn't say, I heard this from 5 or 6 people. You said it emphatically, first person, in fact. So how can we tell when it's you're relying upon in your memory or unnamed people? How do we know?
Objection. Objection to Mr. Cogdell, sorry. Objection to Mr. Cogdell
Have
stating...
I shown you nothing, Dick? Nothing?
Well, we've known each other for at least 30 years, but my objection is to Mr. Cogdell making a statement of what the record says and then asking him a different question about it. It's a statement by counsel rather than proper cross-examination.
Look on page 18, Mr. Maxwell, of your...
I'll sustain the objection. You can rephrase it.
Yeah, thank you. And I'm sorry I call you judge. It's just reflex, Your Honor.
You can call me anything. It's fine. I'm just
Let's
here
don't get carried away.
I just have this job.
If you will look, Ranger, on page 18, I believe line 3.
Okay.
Would you read out loud what you tell the House managers on page 18, line 3?
Yes, yeah, his travel aide, who was with him all the time outside the office, went with him to, and there's a hyphen, would have meetings with him, and also in one instance carried some documents and gave them to Nate Paul in a dark alley one night in the middle of the night.
Okay, so you would agree with me, and to satisfy Mr. What's the name?
Touche.
Both of you need your names in the hat right there.
Yeah,
Okay.
to satisfy Mr. Touche, you would agree that you didn't qualify this statement, Ranger, that it was told to you by 5 or 6 people, right?
What are you asking me to agree to?
You would agree to me that when you told the House committee this story about Drew Wicker, you never said you had heard it from someone else.
I did not.
Okay. So my question remains the same. Since you didn't qualify or explain your answers that were based on hearing it from someone else, how do we know, Ranger, when you're telling us something that you know your own personal knowledge as opposed to hearing it from someone else?
There is no comparison between giving an investigative committee a lead to go and investigate. I never said that I had any personal knowledge of that.
Okay. Let's try again. What's the answer to my question, Ranger?
Which is?
Third time. Since you don't qualify your explanations and explain to us whether they are based on first-person knowledge or you heard it from somebody else, how do we know what you are basing your explanations on?
My explanations of what? Now, what are you referring to when you say, what did I base my explanations on?
My objection was asked and answered.
Actually, he hasn't answered.
Overruled.
Now, so that you and I are clear, Ranger,
Okay.
you are a fellow that's taught folks how to testify, right?
Say it again.
Why is it that every time I ask you if you've taught folks to testify, you suddenly can't hear the question?
Actually, my testifying, I learned by experience.
Okay. And is that one of the things you've learned by experience, Ranger, to pause and act like you haven't heard the question?
Maybe.
Fair enough. Well, what did you learn?
I learned that it throws you off.
Does it? Does it? Okay. And that's your intent, Ranger? Rather than testifying to the truth and giving direct answers, your game is to throw people off? Is that where we're going, Ranger? Is that where we're going?
No.
That's what you just said. That's what you just suggested.
I just said that I do sometimes pause.
Ranger, you also told the House committee that Ken Paxton met with the Travis County DA and requested that the Travis County DA's office refer the case to him. You remember telling him that?
And referred the case to who?
To him, Ken Paxton.
Yes.
Okay. Who told you that?
Don Clemmer.
Okay. That's really interesting. Because are you aware, Ranger, that it was Don Clemmer who told Mindy Monfort and Miss Moore, hey, I don't want to deal with this. Let's give it back to the AG's office. It was him that came up with the idea. Are you aware of that?
I know that Don Clemmer, when I made the phone call, called to him, and I was chewing him out about sending that over to me, that he told me it's not his fault that Ken Paxton requested it be sent to me.
Objection non-responsive.
Sustain.
Excuse me, Your Honor, but
No, he's not answering the question, Mr. Touche. He's
my
not.
objection. My objection is that Mr. Cogdell cut off his answer when the answer was responsive to what Don Clemmer told him.
No, that wasn't the question. The question was...
Overruled and rephrase the question.
Yes, sir.
Make it clear.
Yes, sir. The question is, Mr. Maxwell, are you aware that it was actually Don Clemmer's idea to refer the case to the Attorney General's office? Not Ken Paxton's. He wasn't even aware that that process could occur. It was Clemmer's idea, not Paxton's. Are you aware of that?
Objection to the form of the question, inserting what Ken Paxton knew.
Sustain.
Are you aware that the idea to refer the case to the AG's office came not from Ken Paxton, but from Don Clemmer? Are you aware of that, yes or no, Ranger?
Objections, that's a fact, not in evidence.
I'm trying to get it in evidence.
But it's the lawyer testifying.
Overruled.
Fifth time, Ranger. Are you aware that it was the idea of Don Clemmer to refer this matter to the AG's office? Are you aware of that, yes or no?
No, that's
Thank
not
you.
what he told me.
Okay. You've told the House committee, Ranger, that actually it was your lawyer, Mr. Turner. Is he here today? Did you say that?
Mr. Turner?
Yes, sir.
Yes.
Where is he?
He's in somewhere. I think he's in the chambers.
Okay. But he was with you while you were being interviewed by the House managers, right? Back in February.
That's correct.
So you were present when your lawyer told the House committee that Paxton drafted the contract to Kamek and Paxton took Kamek over to the DA's office.
Yes, I was there when you
Okay.
said that.
Yes, sir. So look at page 49, Ranger, of your Board of Managers interview. If you'll look, Ranger, at, I think, line 3 down, your lawyer says what David's talking about is after David and Mark refused to approve hiring of outside counsel, Attorney General Paxton actually drafted and sent the contract to this guy, Kamek. That's what your lawyer tells the Board of Managers, right?
Yes.
Where did he get that from?
I don't know.
Did you hear that from somebody?
Sure.
Who'd you hear that from?
Say it again. Who's what?
Really?
No, I'm being serious.
We're going to be here all day. Who did you hear that from, Ranger? Who did you hear that Paxton drafted and sent the contract from?
I don't know who has that information. I wasn't involved with Kamek.
Objection, non-responsive.
Okay.
Sustained.
Ranger, I'm asking you, who told you that Ken Paxton drafted and sent the contract to Brandon Kamek? What is the name of the human that told you that?
I don't know that.
I'm not asking you if you know that. I'm asking you who told you that. Those are two different things.
I think the statement was made by my attorney.
And you said, after I pointed out, Ranger, that your attorney made that statement, you were the one that said, I had heard that. And I am asking you who told you that.
I would think it was Mark Penley.
Mark Penley. Okay.
Because Mark Penley was involved with that.
Okay. And your lawyer, Mr. Turner, Ranger, goes on to say, and then referring to Paxton, and then took him over to the DA's office and introduced him to them, where he went to the grand jury in the auspices of being his special prosecutor for the Attorney General's office and obtained somewhere around 40 subpoenas. So your lawyer is telling the committee that Ken Paxton took Brandon Kamek to the Travis County DA's office, to the grand jury, introduced Kamek to the Travis County DA's office grand jury, or the Travis County grand jury, and Ken Paxton got Kamek to get the 40 subpoenas. That's what your lawyer told
Objection. The objection is he's trying to cross-examine the witness from another person's statement. The lawyer, he's only recited what the lawyer said, not what the witness said in that statement.
I didn't think there was any confusion about that. You were sitting right there when your lawyer is telling the DA's office.
Sustained. Try a different approach.
You are sitting right there when your lawyer is telling the committee that Ken Paxton took Brandon Kamek over to the Travis County DA's office, right?
Right.
Was that your understanding of what happened? That Ken Paxton took Brandon Kamek to the DA's office?
Like I said, I have no direct knowledge of it. I talked to Mark Penley a lot. He may have told me that.
Okay. And your lawyer goes one step further and says that Paxton introduced Kamek to the grand jury. Is that your understanding of what happened?
I don't know. I don't know if that happened or not.
Okay.
Yeah, objection to cross-examining from what the lawyer said, not what Mr. Webster.
I am certainly free to test this witness's memory about what happened and what didn't happen, and if this lawyer is making falsehoods while he's sitting there, I can cross-examine him about that all day long.
Sustained.
Did you tell your lawyer, or where did your lawyer learn from this? Where did your lawyer learn this claim that Paxton took Mr. Kamek to the grand jury?
Objection. This Law School 101 says you can't ask a client what he told his lawyer.
I'm not asking him. Law School 101 would also teach you to listen to the question. Where did your lawyer learn that Paxton took Kamek to the grand jury?
I have an objection pending as to inquiring about conversations between Mr. Maxwell and his lawyer.
They're not privileged. They're in front of the House committee.
Can both of you come to the bench?
You've been listening to cross-examination of David Maxwell, who was the former director of law enforcement for the AG's office, from Dan Goudeau of the defense team. And things get in a bit heated and tense.
Well, it's kind of interesting to see, like, are we joking here, or are we really trying to, like, throw some stabs? Brad Vinson, local Austin attorney, kind enough to spend his afternoon with us.
Happy to be here.
Yeah, Brad, how's this going?
Well, I think just recently on this little bit right here, it brings up some attorney-client privilege issues, and that's what they're arguing about at the bench. And I think that I was surprised that with the witness before this one, I think it was Vassler, at how many issues were attorney-client privilege between him and Sutton that they were allowed to discuss and that no one objected to. So it seems like this is the first time we're finally getting some attorney-client.
Yeah, we were remarking about that yesterday too.
To be fair, though, that directly speaks to one of the articles, because he says he was fired because he sent some secret grand jury subpoenas to his personal attorney and then deleted that. And then so I think for him, you've got to bring that up. I don't see how you don't say, if he's saying this is why I was terminated, or if the defense saying, no, that's why you were terminated, not because of the whistleblower report. I think that's a direct, but this seems to just be
right. And there's a difference between what's relevant and what's attorney-client privilege, and the privilege would outweigh that relevance. And then that's similar to kind of invoking the Fifth Amendment. From the defense side, you ask the question, hoping they're like, nope, that's protected, and then it's like, well, why are you not wanting to talk about it? Why won't you tell us?
What do you think about how this cross-examination is going? I mean, is Goudeau landing any punches at all?
I really don't think he is. There's just nothing there. You know, he came out in direct. He laid his story out so simple, so plain, direct to the point.
In almost a folksy kind of way.
I think he's getting nothing.
Well, the other thing is, and to your point about Tony, are we joking here? Are we friends?
Yeah. It's hard to know.
David Maxwell, who has composed himself, I would say, quite impressively, in all standards, and being so straightforward, made a little joke. It seemed everyone else thought it was a joke, and the gallery and all of the senators on the floor started laughing. But then it seemed like Goudeau tried to turn that against him, and
yeah, that was strange. It was almost as if Goudeau was laughing with him, invited him into the joke, and then chastised him for it. And I don't think it landed very well.
And as though a witness taking a pause to throw a questioning attorney off, like, well, isn't it the job of the questioning attorney to try to throw the witness off as well?
And an older gentleman wanted to take a pause to think about and be thoughtful about what you're saying to the defense. But looks like they're starting back up, so let's listen in.
Took Brandon Kamek to the DA's office. Do you know how your lawyer?
I do not.
Do you know how your lawyer learned that Paxton took him to the Travis County grand jury?
No, I don't know how he knows that.
Do you know how your lawyer learned that Paxton was with Kamek when he obtained these grand jury subpoenas?
No.
Well, when those statements were being made, Ranger, did you, David Maxwell, stand up and say, whoa, 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 where'd you learn that from? Where'd that come from? What are you basing that on? Did you say anything to suggest to the committee that those statements weren't accurate?
I don't know if they're accurate or not.
You don't know if they are or they aren't, apparently.
You're right. I don't have any knowledge of it.
Okay. So that I'm clear, are you suggesting to this jury, to these 31 senators, that it's perfectly permissible for you if your lawyer makes a statement to the House committee and you have no personal knowledge whether it's true or not, you're fine with that?
I am fine with somebody making a statement that they know something about. It doesn't, because I don't know, doesn't mean it's not true.
Okay. Well, do you think, Ranger, that Ken Paxton took Brandon Kamek to the DA's office?
I don't know the answer to that.
Do you think, Ranger, that Ken Paxton took Brandon Kamek before a grand jury?
I don't have any direct knowledge.
Okay. Do you think, Ranger, that Ken Paxton was with Brandon Kamek and helped him get those subpoenas? Do you think any of those things are true?
I don't know the answer to it.
Okay. So, when you left the interview with the Board of Managers, after that point in time, did you learn that any of the information that you had been provided or that your lawyer had provided was incorrect? Did you ever find out anything that was said was untrue or inaccurate?
No.
Okay. And of course, had you would have brought that to their attention.
I would.
Okay. May I have just a minute, Your Honor?
I'm sorry, say that again?
It's catching now. Everybody's got it. Can I have just a second?
Yes, yes. The acoustics in here are not the best.
Never mind. We were taking a moment for Goudeau to talk with the other
Ranger,
defense attorneys, but they're starting back up, so let's continue to listen in.
You never had any intention of investigating any of this, did you?
When I read the allegations, I never had any intentions to open up an investigation. That's correct.
You never had any intentions of finding out whether or not Mr. Kamek and Mr. Wynn were telling you never had any intentions of doing any investigation, right?
I plainly stated I was not going to do an investigation.
Okay. You didn't so much as make a phone call, right? You didn't make a phone call to investigate. You didn't get on PACER. You didn't do TCIC. You didn't do NCI. All that litany of accessible tools that you had at your disposal, you didn't do anything, right?
I did not run him through any of our databases.
And you never had any intention of conducting an objective, fair, reasonable, thorough investigation, did you?
There was no investigation to be done.
Objection, non-responsive.
Sustained.
Do you remember, Ranger, when we went through the litany of characteristics of a good investigator in the beginning of your direct examination?
Yes.
They should have an open and an objective mind, right?
Yes.
They should act without bias or predisposition.
Yes.
They should be willing to follow the evidence.
Yes.
Should conduct an investigation timely, right? Should conduct an investigation timely.
Yes.
And that they would know that no person is more or less deserving of their best efforts than another person, right?
Yes.
The investigation should be thorough, right?
It should be, absolutely.
And they should generate and keep accurate records and reports, right?
I didn't quite catch that last part.
Now I couldn't hear you, that's the first.
I'm sorry.
It's all right.
I didn't quite catch the last part of the
Yes,
question.
sir. That if someone's going to do a legitimate investigation, they should keep accurate records and reports.
Absolutely.
Okay.
Yes.
And you never had any intention of doing any of that, right?
There was no investigation.
That's a no? You never had any intention of doing any of that?
Right.
Okay. That's all I've had, Ranger. Thank
Okay.
you.
Redirect.
How much you got? You want me to get this out of the way? My name is Todd.
And we've been listening to the final testimony, final cross-examination testimony of David Maxwell. Looks like Dick DeGuerin is going to ask a few additional questions on redirect. Let's go to him now.
Once you were told that Nate Paul was the person that General Paxton wanted you to meet with, did you find out who Nate Paul was?
I did.
And once you found out who...
This is asked and answered on direct, same question.
Sustained.
Did that... When you found out what he was and who he was, did that make the back all that other stuff that Mr. Cogdell talked about unnecessary?
Leading and asked and answered.
Whether or not did it make it unnecessary?
Asked and answered on direct.
Sustained.
All right. Mr. Cogdell asked you several questions about your conversation with Don Clemmer, the man in the Travis County District Attorney's office. So what did he tell you about this?
Objection, hearsay.
He opened the door, Your Honor.
No, I didn't suspend the rules of evidence. Objection.
Starting
hearsay.
on page 78, line 15, there were a number of questions asked about the conversation with Mr. Clemmer, even to the point of what Mr. Maxwell said to Clemmer. I believe the door's been opened. I believe it's admissible, and I'm asking that the court allow it.
Open the door is not a hearsay exception.
Overruled.
Go ahead.
Yes, Don Clemmer told me that Ken Paxton requested the investigation be sent to me.
And what did he tell you about his opinions about the review?
Objection, hearsay. I didn't ask about that, even though I contend you can't.
Sustained.
In the presentation, this PowerPoint presentation, was there a part of it that listed 6 people to make targets of an investigation Mr. Paul wanted you to conduct?
Yes.
What was your opinion about whether that was proper?
If we followed the PowerPoint he created and conducted that investigation, we would have committed several federal crimes.
What are they? What are the crimes that you...
Obstruction of justice, interfering with a federal investigation.
That's all. Thank you.
Recross?
Yes. Let me get this straight, Ranger. So if the feds break into my house, break the door down, hold my wife at gunpoint, kick my dog, cut off my internet, search my house without a warrant, and I want that crime to be investigated, you're telling this jury with a straight face that that's obstructing justice and interfering with a federal investigation? That's your position? Ranger, you're smarter than that.
They did have a search warrant, and they did execute it, and it was lawful.
You don't know if the search warrant was lawfully issued or not. You don't have a clue, do you?
Mr. Nate Paul doesn't have any evidence that it wasn't lawful.
Witness, please.
Arguing with the witness. Objection.
Sustained.
Have you ever analyzed the search warrant affidavit to see if it establishes probable cause for each of the search warrants that were issued?
Mr. Paul did not provide us with the
Objection,
document.
non-responsive.
Sustained.
Ranger, you're smart enough to know what question I'm asking and whether or not to answer it.
Objection to the sidebar remark.
Ranger, are you smart enough?
Hold on, there's an objection pending.
Slow down, gentlemen. Slow down. I
Yeah.
sustained your objection. Go forward.
Yes, sir. Ranger, are you smart enough to understand my question? And are you smart enough to answer my question?
We analyzed the material he gave us. That's all I have.
Sustained.
I think we're done here, Ranger. Good luck, sir.
Witness may step down.
And our fourth whistleblower has just finished testimony in this case, 4 of 8 who testified at the impeachment trial for Texas Attorney General Ken Paxton. I think a question will be whether or not we hear or they call another witness today, Ashley.
Yeah, we're having a hard time hearing what's happening, so I just want to listen in.
Cogdale, come up for a second.
Like they're approaching the bench.
Yeah.
So yeah, it looks like Lieutenant Governor Dan Patrick
Yes, why
calling.
don't you all take a 10-minute break? Stretch your legs and be back at 4:40.
So there you go, taking a brief 10-minute, 12-minute break so everyone can stretch their legs. Now, this raises an interesting point. The Lieutenant Governor said yesterday he wants to go until 6 p.m. today, right? He said he had thought about letting them go at 5, but the senator said, well, we're going to be in traffic either way, so we might as well stay till 6. And if I were the prosecution, right, no legal experience, clearly, I would have wanted to end it on Maxwell today.
Yeah, we were talking about that earlier. I mean,
But now it's 4:30. You got an hour and a half left.
Right.
I think what they're going to be talking about is, do we want to call another witness or do we want to let everybody go home?
I think if I was the House committee, I'd be pushing Patrick to let us push out, be done, to leave for the day.
And why so? By the way, Brad Vinson, if you're just joining us, Austin attorney who is spending his afternoon with us, and we're so appreciative of him. But yeah, why would you want that?
Because
Brad?
they end memorably with him on the whistleblower portion of their arguments, right? Several of the articles are attached to the issues related to the whistleblowers. You've heard from 4 witnesses now. All of them have been good. This guy was great, right? And so you end there, you end memorably, you give everyone something to think about. I think that would be great for the House committee side.
Why was he great?
He was great. He was powerful. He was direct. He was to the point. I mean, he's about as true of a Texan as you can be, right? And I told Tony earlier, it's like this guy was sitting on his couch at home talking to all of us. I believed everything he said. He was so credible, right?
So do you think Dan Cogdell really landed any punches with him?
I don't think he did at all. I think there at the end we got to see what his strategy was, and that his strategy was to basically build up like all of his experience, everything that you're supposed to do in law enforcement, and then at the very end say, well, you didn't do any of that, did you? You didn't even give this case a chance. You weren't objective. You didn't give it, even the time of day. And it's really kind of misconstruing the facts, because he's saying, well, no, I looked at it and I determined that if we went forward with an investigation, we would be committing crimes.
Obstruction of justice.
I thought it was interesting. Not only did he look at it, he talked about how at one point, because Nate Paul had this notion that the search warrant of his properties had been altered sort of on the spot after agents didn't find exactly what they were looking for, that he actually sent some things off to a forensic lab that did work for the AG's office. This is what Maxwell said. So these are experts who would have been able to tell if something had been tampered with. So it's not necessarily, or at least his testimony is not that he didn't look into it. His testimony is certainly that I did find something, but I thought this was, what stood out to me, his quote, absolutely ludicrous.
Yeah.
That's how he described these claims.
Yeah, Brad, I want to examine that with you a little bit more. I mean, certainly, we are familiar with law enforcement making missteps, sometimes even as a group, a small group. I mean, I think of George Floyd's murder in Minneapolis, for example, where there was a collection. But what's so striking about Nate Paul's claim in this situation, David Maxwell calls it a conspiracy theory, is that it involves officers from multiple agencies, a magistrate judge, a federal magistrate. Yeah, so to get everybody on the same page about this, grand conspiracy to mess with Nate Paul. Can you just speak to that?
I mean, it definitely has its tinfoil hat, vibrations to it. It's so clear that how could so many different people from so many different agencies, state and federal, be involved to attack this one person, right?
And why?
Why?
Tony,
what would be the motivation? Yeah.
What is because yes, he's been indicted,
right? I guess is the play. At least from the defense side.
And tell our viewers a little bit more about that.
Right. So, and Tony Busby, I think, previewed that during his opening. He said that the Mitty Foundation is crooked and twisted, and that they've got issues, right? And I think they're trying to preview that and say that that Nate Paul's involvement with the foundation is the target of why these things happened. And Paul is basically saying that this conspiracy is being protected by all these state and federal agencies to his detriment, which again seems absurd.
Bringing that up with Ryan Vassar when he was talking about how the money that the foundation was using, money that a charitable organization was using, millions of dollars to enter into sort of a deal with a real estate investor.
I mean, there's plenty of nonprofit organizations. People hear the word nonprofit and they think small, but there are plenty of nonprofit organizations that are massive, that have hundreds of millions of dollars, right? And I think that the defense is also trying to play that, right? They're trying to make us think like about the small nonprofit down the street that's got just a few employees and barely making it, but there are plenty of nonprofits that are very successful nonprofits.
It's just very interesting to think that they would go through all of this elaborate scheme for one Austin real estate investor.
Yeah. I understand, and I often, like I said, I practice as a criminal defense attorney, so a lot of my job is creating all this doubt and sometimes creating things that sound like conspiracies, and I certainly understand and appreciate what the defense is trying to do, but oftentimes the state will get up in opposition to me in closing and say the defense wants you to believe that all of these things happened, right? That all of these things are just absurd. They all happen and they don't indicate guilt, when really you just have to simply look at it and say, look at the totality. It all adds up that something happened here.
Brad, there's no coincidences in Austin.
Well, apparently, so I've heard.
3 times in this one hearing for the first time, right?
So yeah, any additional thoughts on just sort of David Maxwell's overall testimony, how it fits into the big picture?
Sure. Like I said, I thought that he testified great. I love the way he ended his direct when he said that he didn't think it was wrong doing the right thing. I really think that they've gotten out of him some really important things that were from a witness who would never go against a government agency that he's working for and against an elected official who he seemed to have a lot of respect for. And that's what we've gotten from each one of these witnesses, is the relationship with Ken Paxton and the relationship with the office and the pride that they had And the question then is, why would these people, come here and testify otherwise?
If you are a Paxton supporter or a senator who is on the fence or a senator who is wanting to acquit, what are you thinking at 4:35 on, after 4 days of this trial?
I'm thinking the defense better back up what they talked about in opening. They better bring me something that shows me why the Mitty Foundation is problematic. They better bring me proof that the home improvements were paid for by the Paxtons. They better bring me proof that that this relationship wasn't a quid pro quo to continue an affair. They need to prove that. They need to bring that evidence. And even though the burden of proof is beyond a reasonable doubt, and the burden is placed on the House committee, in a case like this, the defense, you got to go in. You got to put on your evidence. You got to put on a show if you want a chance of winning.
It's interesting that you talk about the Paxtons paying for their renovation, because that is certainly
key to all of this.
Key to bribery, right?
Yeah.
That Ken Paxton was doing all of these things, and in return, Nate Paul, A, hired his mistress, and B, paid for his renovation. And we heard during the opening statements, Busby say, well, don't you know that there was an insurance claim and that they actually made a payment? And then we also know that from the House documents, the documents that the House had to submit, that Ken Paxton did, there was a payment made of $20,000.
Right.
That I believe it was the day after.
To Cupertino Construction, whatever it is.
And this was after the whistleblowers, though, had told him that they had reported him. And so, but you could say that that's the time frame that the insurance payment came in. Sure. So is that reasonable doubt?
For sure, absolutely. I would say it is, and I would hang my hat on that if I was the defense. I would come in very strong with that. But then, that there are catch-all provisions, catch-all articles that we talked about here. So we've talked about there's 16 to beat, right? So even if you beat that one, you say that there's reasonable doubt about the fact that he made that payment later. There are catch-alls that can say, like, even though he did that, we still think it was inappropriate. We still think that he was abusing his office.
When you think about the style of the attorneys and how they're coming off, because if that's the case, you're going to have the prosecution try to say, oh, well, he was just covering it up because he knew what was coming. And you're going to have the defense saying, no, this was the plan all along.
Yeah, this was legitimate.
And so you almost have to figure out for the jurors who they want to believe. And so the demeanor that the attorneys are taking during these proceedings, again, because everything is calculated, how can that help or hurt them when it comes to when the jurors are ultimately going to have to decide, who am I going to believe?
I think in most cases, in most trials, the lawyers that are involved care a lot about what the jurors think. But in this case, I don't know that the theatrics really matter that much for the jurors, because the jurors are senators, they're politicians, they have biases. None of these people would ever be able to actually
sit on a real juror. Exactly.
Sort of
a point.
That would have been removed from the panel for sure.
Yeah, and as we take a live look at the Capitol there, Ashley, I don't know about you, but some of those people look like they're about to go home. I'm seeing some bags over shoulders and so forth. They're ready to call it a week.
It's been a long few days.
It's been a long few days.
4 days, so I do think we certainly wouldn't be. Well, yeah, there's State Senator Angela Paxton putting her purse on her desk and going through.
Yeah, for sure.
Well,
we'll find out soon.
We'll find out. Yeah, supposedly we'll find out in 2 minutes.
It does.
Whether this is an extended bathroom break or
it does. Definitely some people are saying with their body language and so forth that they're ready to go home. But it certainly looks that way, and you can certainly understand it's been high stakes. Oh my gosh, the pressure. The pressure is less today, but my goodness.
So I do want to know, you're looking at video from one of the photographers, the pool photographers who's on the floor. The Senate feed itself, if you were to log on to the Senate feed has been cut. Bob
Buckaloo, our producer, who, thank you, Bob, for all of your help today, is telling us in our
Yes, here
ear
it is,
that they are done.
That they are done. The Senate feed is actually saying that they will resume Monday at 9 a.m. That they are finished. Now that
Yeah, I
obviously-
am seeing other tweets from other reporters at the Capitol saying they have adjourned.
We certainly didn't hear that.
I
Don't
did
know
not
how
hear
was
that. Yeah,
entered
yeah.
into the record. But they are done for the day now. Ending again, as we've kind of said, you know, we're not necessarily surprised. Brad, local Austin attorney, certainly said this is how you wanted to end the day.
Yeah, if I would have been the House committee, this would have been a great way to end. I think that that witness was absolutely incredible for the House committee side, so we'll see what happens on Monday. Right?
So let's take a step back and rewind then. Now that we know that we are officially done for the day.
Right.
So 4 whistleblowers.
By the way, we'll all see you on KVUE News at 5 in just about 20 minutes.
We will. Big takeaway for you this whole week, hearing from attorney, former director of law enforcement. Biggest takeaway, biggest moment.
I think that last witness really did it, right? I think that he really brought home exactly what they were trying to show, right? When you talk about starting powerfully and ending memorably, you came in with the highest ranking official, Mateer, and then you backed it up with the real clinical, almost cold clinical, but like still, there was still heart there. I keep forgetting his name. Who's the second witness?
Banger, excuse me.
Banger's
Yes.
He was an incredible witness as well. He was very clinical. Nothing could disrupt him. Vassar was okay, but he's kind of sandwiched in between him and Maxwell ends just perfectly. So the biggest takeaway is that it just doesn't seem plausible that this many people that had so much love and admiration for their jobs in the government, for their ability to work for this state, for the AG's office, and for the AG, that they would conspire to take it down in the way that they did, to take him down this way, unless they truly believed that a crime had occurred or was occurring.
What do you make of this defense posture that, well, they just got it wrong?
I think that it's all they can do. It's what they have to do, right? What else are they going to do? I think they have to go with, they're all wrong, everyone's wrong, all of these things were being targeted, they've misstepped, they've assumed, that's what they've said from the beginning.
Yeah.
All of these assumptions.
Hearsay, etc.
It's all hearsay, it's all been assumed, and there's nothing really there.
And I think one of the things that raised our eyebrows, and we kept hearing it over and over, is and say, well, why didn't you just ask Paxton? Well, if you thought that your boss was having this renovation paid for by this investor, or if you thought he was doing, why didn't you just ask him? How reasonable is that actually?
Well, it's a misstatement of what happened, because every one of these witnesses have said that they did ask him, that they did approach him, that they did talk to him, and I think one was really
cut ties with him, or
That's
you're going
right.
to get indicted.
Yeah. We just heard from Maxwell. Stop working with him, or you will be indicted. I mean, it doesn't come more clear than that.
Yeah. Well, we are going to have much more analysis for you on KVUE News at 5 o'clock. We certainly hope that you will join us, and even more so, right back here on KVUE Plus Monday morning, 9 a.m. We'll be back fresh with that gavel-to-gavel coverage.
And again, a special thanks to Brad Vinson, who has been generous with his time with us today to help us unpack and understand all of the issues at play here.
Thank you both so much for having me on.
Thank you.
Thank you, and thank you for watching. We'll see you Monday.